Ms. Monroe, the criteria and the reasons for the sentence is the nature and the gravity of this offense, the punishment or discipline to you that is appropriate, the potential for your rehabilitation or reformation, the protection of society and deterrence against you or someone else committing this offense again. First of all, I would like to thank all of the individuals from the family who spoke today, everyone, and I'll just briefly recap what each person said. Ms. Evans testified about the fear that she had when she realized she had been involved in this accident for herself, for her daughters. Ms. Pack, who bravely came up and spoke about, again, her fears with this terrible incident. Captain Tiefel, who spoke on behalf of the Firefighters Union, talking about losing a brother that day in John, and he made a statement that was particularly poignant to this court. He said, this is from the captain, that you, Ms. Monroe, took away someone who would have moved heaven and earth to help people. And that was his brother, his firefighter brother, John, who worked as a paramedic. And as we've heard his wife and other people talk about, really seemed to connect with the most vulnerable people in society and really fight on their behalf to make sure that those people were properly cared for medically when they themselves were having their own issues. And Ms. Monroe, it sounds as if had the situation been different, and he would have cared for you too in that incident. We heard from Dr. Glatz, the widow of John, who, again, she talked about how her husband would sit and talk with patients that he dealt with as a paramedic, who offered no judgment to those people, who even if those people who were constantly slipping in and out of addiction, needing the services of emergency medical personnel, and yet he would still tend to those individuals, as was his obligation and his job, and frankly, as Dr. Glatz indicated, his desire as a paramedic professional to help the community in the manner he did. We heard from Mrs. Ash, John's mom, who talked about the kindness of her son and how he cared for others, and that was exemplified in everyone's statements today about John and Dan, and how again, this family has lost such a great deal in losing these two men, and having other members of the family, including the youngest members, be injured, and what it sounds like facing a long and painful road to recovery. We heard from Ms. Fabrice, who talked about her 2-year-old who had to endure and is apparently still going through the symptoms of PTSD, who had to seek out counseling, who the family has had some challenges with depression and feeling like they themselves were responsible for this. Since the day that this happened, they were gathered to say goodbye to their family, their small family, who was taking another job overseas. And we heard from Mr. Ash, from John's brother, who really eloquently said, in addressing you, Ms. Monroe, what you're getting today is nothing like what our relatives have been going through for the past 515 days. So in other words, the sentence today, and I think other family members said this, this family is going to have to live with the memories of this terrible, terrible, tragic day for the rest of their lives, whether it's from their own memories of the incident, of the crash, of themselves, their family being injured and killed. A number of these family members have talked about reliving those moments in their lives and not being able to see a day where they don't either experience the physical pain or the mental pain of reliving those moments. Mr. Esch also talked about the fact that, again, the powerlessness of himself not being able to help some of the victims, while his wife, on the other hand, was performing CPR in a failed attempt to revive her brother-in-law. And again, I think that it went without saying that this was one of the best days. This day started out as one of the best days in this family's lives. Family traveling from out of state, from out of the area to meet, to say goodbye for now to Monica and David, who would be moving overseas, and their young daughter, enjoying time outside in the sun. And I do remember that this was a beautiful day outside. They were gathered in the park to enjoy, and I think someone said playing in the same playground that some of the family members played in when they were young children, and just enjoy each other's company. And it became the worst day of this family's life. We heard from Mrs. Harris, Dan's wife, who talked again about her own horrific injury, her own struggle for survival. We heard the prosecution say they originally thought this might be a 3-count homicide case, but through her own persistence and desire to carry forward, despite her husband's death, she survived. And we heard her struggles, and we heard Aurora's elocution about losing her dad. Well, we heard again statements from the family, and I'm just compiling them here. They will never be able to live normal lives again. And at the end, once all the family members had made their statement, the prosecution, Ms. Martinez, said she has wondered, why do things like this happen to people like this? People that were just out enjoying their time together. And really, I don't think there's a good answer to it. But what we do know is that Miss Monroe, the defendant in this case, made what I understand to be the worst choice that she's ever made in her life. She made the choice to, while on prescription medication, consume a very large amount of alcohol to the point where her blood alcohol level was, as has been stated, 0.195, way more than anyone should be consuming, and then making the choice to step behind the wheel of a vehicle and then operate that vehicle and unfortunately crash into this family. And I agree with Ms. Martinez's sentiments that many miracles happened this day, and it is a miracle that we are not here mourning the losses of more of these family members. And it's funny because Ms. Martinez also talked about the fact that out of all of the family members that were present for this, again, what should have been a joyous gathering of these family members, the 2 people who perished, from what the family has stated about those 2 people, those are the 2 people that would have sprung into action to protect their kids, their nieces, their nephews, their wives, their mothers, and I guess, and I of course didn't know any of these people personally, but from the statements made, they displayed acts of heroism that, again, most likely reduced this incident from something that could have been even more tragic than it already is. So again, Ms. Monroe, I'm sure that if you could dial back this incident, and you know, you didn't make a statement, and I don't hold that against you in any way, but I'm sure that if you could dial back this incident, you would. But unfortunately, you can't. And as all of these individuals, all of these family members said, they are going to have to deal with and the consequences and the ramifications of your actions for the rest of their lives. And I don't know that there's an explanation for what happened other than your choices that day. But I do know that something like this cannot happen again. Not here in this community, not here in Clinton County, not here in the state of Michigan, not ever. And so I do need to sentence you to a sentence that will not allow that to ever happen, not allow you to make these same choices again. I have reviewed the recommendation that's been provided to this court from the Michigan Department of Corrections. I believe it is in line with what the plea agreement is. And once again, I note that your sentencing guidelines permit me to sentence you from somewhere between 18 years to 31 years on the minimum, up to a longer term. And the recommendation provided to me by the Michigan Department of Corrections accounts for, yes, your criminal history, which you do not have any criminal history to speak of, but it also accounts for the horrific acts that occurred on this day on May 18th, 2024. And their recommendation for the homicide murder second degree charge is 30 years to 60 years with credit for 515 days served. And I intend to follow that recommendation. So as to the count 9 homicide murder second degree, I sentence you to the Michigan Department of Corrections for a period of 30 years to 60 years with credit for 515 days served. You must pay the court costs in the amount of $350. You must comply with DNA testing and pay a $60 fee as ordered. You must pay a $68 state cost. And this will be served concurrently with all of the other counts. This is count 1 through 8 of operating while intoxicated, causing serious injury. You will serve that sentence in the Michigan Department of Corrections for a period of 2 years to 5 years with credit for 515 days served. Those counts will be served concurrently with each other and concurrently with the second degree homicide sentence that I just handed down. You will not have any verbal, written, electronic, or physical contact with any of the victims in this particular case, and all of the victims' names are listed in the pre-sentence investigation report. You will not have that direct contact or be within 500 feet of their residence, school, or place of employment. You must pay restitution in the amount of $73,128.44. $66,093.44 will be payable to Auto Club Insurance Association. $7,035 will be payable to the Michigan Department of Health and Human Services, and you must execute a wage assignment to pay restitution if you are employed and miss 2 regularly scheduled payments. You must pay $544 in state costs, comply with DNA testing, and pay attorney fees as ordered. And these fees will be determined. So I want to say one more thing as to your sentence with the Michigan Department of Corrections. This does not, again, not to minimize any of the family members who came in here and talked about the fact that for the rest of their lives they will relive the moments of this tragedy. But Ms. Monroe, I know you are going to a place, and I noticed in your pre-sentence investigation report And I also noticed, but based on some of the certificates that you presented the court, that you do have, and I think it's obvious, a substance abuse issue that is the reason, one of the reasons why this terrible thing happened. I implore you to take advantage of any possible rehabilitation that might be offered to you within the correctional facility that you will be sent to, and you have a long time to serve, and I implore you to serve it wisely by making sure that this never happens again, and that no one else, and that this sentence deters anyone else from engaging in this type of reckless conduct. So with that said, you will be handed a document that notifies you that if you wish to appeal this sentence, you may do so by sending the one copy of the document to the address listed on the form no later than 42 days from today. The other copy of the form, it's the same form, 2 copies, will be returned to me, and I'll place it in the court file. And I would ask you to initial that copy. Do we need to address anything else from the people?
Briefly,
Sure.
Mr. Vallow from the Department of Corrections just notified me that on the petition that.
Yes, Your Honor. I noticed it was admitted for the crime victims assessment, $130. It's mandatory.
Okay, that will be included then. $130 for the crime victim. Thank you. Thank you for pointing that out. Anything else that we need to address from the defense?
Your Honor, we'll just acknowledge receipt of the notice of appellate rights, and the client initial and date that and provided it back to the court. She's receiving her copy now. Nothing additional from defense.
All right, thank you very much. We are adjourned.
All right, thank you. You may be seated. Kathleen, you're going to have to get up. All right, so ladies and gentlemen of the jury, I've been told you have a verdict, and so I'll ask the foreperson to please provide the verdict to my bailiff. Thank you. All right, ladies and gentlemen of the jury, at this time, we thank you for your service. Again, I don't think any of us could go too far beyond saying that having you for 2 weeks, we know has been a cause for you to disrupt your lives, and so we thank you for your service. At this time, I'll read the verdicts on all charges, and then with respect to that, I will poll each of you just to confirm that it is your decision of this verdict. So with respect to the 9 counts and the furthermore, this jury says that they duly find and impaneled as sworn jurors in this case do find the defendant, Bianca Ellis, guilty of all charges. Those guilty charges also carry with it the furthermore that she did commit the other charge as requested with a finding of all 12 of you. So with that being said, juror number 1, is this your decision?
Yes.
Juror number 2?
Yes.
Juror number 3?
Yes.
Juror number 4? Juror number 5?
Yes.
Juror number 6? Yes. Juror number 7? Yes. Juror number 8? Juror number 9? Juror number 10? Juror number 11? Yes. And juror number 12? All right. Thank you. Again, I thank you for your service on behalf of Cuyahoga County and the 34 judges here. And we, at this time, will rise for the jury, and we'll have a moment to speak to you afterwards. I'll have counsel to sidebar to review the verdict.
everyone be seated.
Thank you. You can be seated. All right, so at this time, having an opportunity to review the verdict forms, the court is going to set a sentencing date. I had asked the lawyers, I'm going to set it for October 27th at, again, 8:30 in the morning. I think we've been pretty consistent with being available at that time. I know that some of you have a trial calendar that might have some conflict. I'll ask that if you can discuss with the courts that you're currently going to be engaged with or potentially going to be engaged with. If I need to call any of those judges, I'd be happy to. But if we could do it, allow everybody that opportunity to be present as well. Anything further from the state of Ohio?
No, Your Honor. Thank you.
On behalf of Ms. Ellis?
No, Your Honor.
All right. Again, I thank all of you for professionalism as well throughout this trial. And so we'll recess at this time, and we'll be back on October 27th. All right. We'll adjourn.
Thank you.
All right, all jurors are accounted for. We can be seated. Mr. Bowie, you're a foreperson. Yeah. Bowie, you have a verdict. So I'm going to review it just to make sure everything's been checked off appropriately. After, if it's all in order, the clerk will ask you each one if this is your verdict, and then we'll take it from there, okay? Okay, all right, Ms. Link. The State of Florida versus Daisy Link, case number F2211523. Verdict, we the jury in Miami-Dade County, Florida, find the defendant, Daisy Link, as to count 1, second-degree murder, guilty of second-degree murder. If you find the defendant guilty of second-degree murder, you must answer each of the following questions. Number 1, did the defendant actually possess a firearm during the commission of the crime? Yes. Number 2, did the defendant discharge a firearm during the commission of the crime? Yes. 3, did the defendant discharge a firearm causing death during the commission of the crime? Yes. So say we all, the 16th day of October 2025, signed by the foreperson. All right, Marilise, we're going to poll the jury.
The jury, you heard the judge read the verdict. As I call your name, if this is your verdict, please answer yes. If this is not your verdict, please answer no. Keenan Bowie?
Yes.
Ramona Espinosa?
So I'll just ask for the pre-sentence investigation to come back the Friday before Thanksgiving, the 21st. Is that all right? That's just for the return of the PSI. It's not for actual sentencing itself. Okay, so 21st is the next court date for the return of the pre-sentence investigation. If it's back then, we can pick a day for sentencing after we get the pre-sentence investigation. Is there anything that I need to address from the parties before we adjourn for the day? I don't believe so. All right. All right. Thank you all. We're adjourned. I can sign this now. Umberto.
the jury foreperson could please rise. Has the jury reached a unanimous verdict?
We have.
If you please can hand the verdict form to the bailiff. Having reviewed the verdict form, it is in its proper order. At this time, I will publish the verdict. We, the jury, find as follows as to count 1 of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Mrs. Adlesen, control yourself. Count 2. We, the jury, find as follows as to count 2 of the indictment, conspiracy to commit first-degree murder. The defendant is guilty of conspiracy to commit first-degree murder. Count 3. We, the jury, find as follows as to count 3 of the indictment, solicitation to commit first-degree murder. The defendant is guilty of solicitation to commit first-degree murder. And it is signed and dated by the foreperson. One moment. Members of the jury, the bailiff will escort you to the jury room. Mrs. Adlesen, while this was not the outcome I'm sure that you desired, there will not be any further outbursts in front of the jury. If you cannot control yourself, I am going to have to determine if you will be removed from the remainder of this process. Do you understand what I'm saying to you? Do you need a moment to collect yourself? Before the jurors are brought back in, we will take a brief 2-minute break. Please give her tissues if she needs them. When the jurors are brought back into the room, does the defense wish to have the jurors polled before they are discharged?
Yes, Your Honor.
Very well. Please bring back in the jurors so we can conclude with their portion of the trial.
All right, go ahead and be seated, everyone. We are back on the record with the jurors, counsel, and parties present. I've been informed that the jury has reached a verdict. Has the jury, in fact, reached a verdict? All right, Ms. Davis, if you could hand the verdict form to Ms. Davis. Would counsel and parties please stand? All right, I have a form of verdict. Form of verdict 2, we, the jury, find the defendant, Karina Cooper, guilty of the offense of murder in the first degree, dated this 11th day of July, 2025. And juror number 1, is that the jury's verdict? Yes, it is, Your Honor. Would you like the jury polled, Ms. Watt? All right. Ladies and gentlemen of the jury, at this point I'm going to ask that you return to the jury room with Ms. Davis just for a bit. We have a couple matters we need to wrap up here, and then I will come and talk to you in just a bit before I release you from your obligations in this case. So thank you, and we'll see you in just a few minutes. Go ahead and have a seat. All right, I will, based on the verdict, I will enter an order, not today, but sometime over the weekend or Monday morning, because I need to get a date and time, but I will set this matter by separate order for sentencing hearing. I will not be ordering a PSI because of the offense charged and on which the jury has rendered a verdict. Ms. Cooper, I need to advise you that you have a right to file a motion for a new trial and or motion in arrest of judgment. Any such motion must be filed no later than 45 days from today's date, but in any event, not less than 5 days prior to the date that is set for sentencing in your case. If you have questions about those, Ms. Watt and Mr. Hawbaker are the people to talk to. Pursuant to Iowa Code Section 811.1, prior bail provisions are revoked and no bond is authorized at this point. Is there any further record that we need to make on behalf of the state?
No, Your Honor, thank you.
Any further record we need to make on behalf of the defendant?
No, Your Honor.
All right, then we are adjourned. Thank you.
All right. Considering that both of these defendants were originally facing multiple counts with the maximum of life, they both benefited from the sentence recommendation that was offered by the state. The crime that was committed, crimes that was committed to Mr. Moreno Ochoa are quite literally unfathomable. I cannot understand the fear that he must have felt when he was trying to be a kind individual. And I do see these two as equal in this. There may be, again, there was an argument about a difference in remorse, but there are differences in this case. Mr. Reynolds comes before the court with, I believe, no priors. And Ms. Fonseca comes before the court with a prior felony and actually 3 prior felonies and a prior misdemeanor, and yet she is 7 years, I think, younger than Mr. Reynolds. So they've each got their own set of this is good and this is not as good. But when it comes to the events, the fact that this happened to Mr. Moreno and Choa, and then 1 week later to Mr. Sanchez is incredible. But the sheer violence of what happened to Mr. Moreno and Choa is, I mean, in his letter to me, he said that Ms. Fonseca looked at him and said something along the lines of, "This is your last day to live." I cannot imagine the fear. He then said she grabbed his hair and pulled it backwards, and Mr. Reynolds slit his throat. And I believe it was 3 times. That, in and of itself, is enough to convince me to the sentence that I am going to sentence. First of all, I know that Mr. Mitchell did not ask for downward departure. Mr. Early did. Mr. Longmire is correct. It is a 2-step analysis. The one is, do they qualify? I quite frankly don't know under these circumstances if substantial assistance is a qualifier. But even if it was, I do not believe it would be appropriate. The sheer level of violence and the fact that there was another crime. And again, I know Ms. Fonseca wasn't the one that committed the second crime, but without her participation, it would not have occurred. And Mr. Mitchell didn't ask for downward departure, but the same analysis would go for Mr. Reynolds. I didn't hear any requests, I didn't hear any of the factors to analyze, but if there were this level of violence in 2 incredibly serious cases, I do not believe it would be appropriate. I do believe that both got the benefit of the bargain. The state offered it, they took it. Under the circumstances, it's going to be in both cases. Both cases, all counts as charged. It's going to be an adjudication on both cases, all counts as charged. Actually, yeah, I think that that is the way it is. Let me make a statement because I think the charges are the same except for when Mr. Reynolds pled, it was to constructive. So the mandatory minimum that was there is not there. So now neither of them has a mandatory minimum. Is that correct, Mr. Longmire?
Yes, Your Honor.
Okay, I just wanted to make that, because what they are left with is the same exact charges.
Correct.
All right. For Ms. Fonseca, counts 1 and 2, 3, CF 4430, counts 1, 2, 3, and 4, 30 years state prison with credit for time served. Do you have that figure?
695 days.
695. 695 days time served. On counts 5 and 6, it would be 229.725 months state prison. And all of those are going to be concurrent and with the same credit.
I'm sorry, this is at 229.725.
Yeah, month state prison, 229.725 months state prison. And in 24 CF 727, it is going to be 30 years state prison concurrent. Would it be 518, Madam Clerk?
Yes, ma'am.
518. If there is any sort of an assistance fee, please assess it. There would be restitution, and it's going to be joint and several to Mr. Moreno Ochoa, $19,500. Again, joint and several with Mr. Reynolds. And to Mr. Sanchez, $3,250. Joint and several with Mr. Reynolds. And it will be reduced to civil lien. Did I miss anything, Mr. Longmire or Mr. Early, as it related to Ms. Fonseca?
Not to my knowledge, Your Honor. $50 public defender fee.
Yeah, I ordered whatever assistance fee would be announced. All right, for Mr. I'm sorry,
Financials.
the due silly. All right, to Mr. Reynolds, on counts 1, 2, 3, and 4 of 23 CF 4430, 30 years state prison concurrent. In counts, it's all as, I'm sorry, counts 1, 2, 5, and 6 as charged. Counts 3 and 4, I guess I don't know whether that was amended. I don't know whether that's considered amended or just as charged. It's just, there is no constructive. Do you understand?
Yes.
Okay,
There's
thank
no
you.
actual possession, just constructive possession.
All right. It's adjudication as charged. It will be all counts concurrent. And in 1, 2, 3, and 4, I already announced the 30 years. In counts 5 and 6, it would be 226.800 months state prison with credit for time served.
695.
Of 695 days. $518 in court costs. If there is any sort of public defender or assistance fee, please assess it. It will be the same restitution. Again, for Mr. Moreno Ochoa, $19,500. Joint and several with Ms. Fonseca. To Mr. Sanchez, $3,250. Joint and several with Ms. Fonseca. And it will be reduced to civil liens. And in case number 24 CF 727, 30 years state adjudication as charged. Again, 30 years state prison concurrent. Is the credit the same in both cases, or is there a different credit for?
It would be, in both cases, they were picked up after the second case.
Okay.
And that's the new one.
So it's going to be, the credit is going to be the same. And Madam Clerk, I should have said this, the restitution to Mr. Sanchez is in case number 24 CF 727 in both cases. The restitution to Mr. Moreno Ochoa is in 23 CF 4430. Did I forget anything, Mr. Mitchell or Mr. Longmire in Mr. Reynolds' case?
No, Your Honor.
All right. You both have 30 days within which to appeal the sentence of this rendered. If you cannot report attorney, 1B24.
Thank you. Ma'am, please. Take your seat back.
Sure.
Austin, are you the foreperson?
Yes, Your Honor.
Has the jury reached a verdict?
Yes, Your Honor, we have.
Chad? Thank you. Mrs. Hartzfield, if you would stand at this time. Ms. Henry, if you would read the verdict, please.
In cause number 23-DCR-0063, the State of Texas versus Sarah Hartzfield, we, the jury, find the defendant, Sarah Hartzfield, guilty of the offense of murder as alleged in the indictment.
All right, you can have a seat. Does anyone want me to poll the jury?
No, Your Honor.
All right. We're going to move to the second phase of this trial. It's much like the first phase, but won't take near as much time generally. You'll go back in the jury room. I'll give them a couple of minutes. We'll come back in. You'll hear opening statements by the state, by the defense. You'll hear witnesses from the state or the defense. And then you'll be given another charge. It'll be read to you, and we'll go through the same procedure as this first phase. So if you would go back into your room, but we'll call you out very shortly.
All rise for the jury, please.
Oh, what a tangled web we weave when first we practice to deceive. The defendant's deceptions, clever little half-truths, her performance, it can get over on some people. She's really convincing if you don't look too closely, if you don't ask too many questions or make her angry. But just like the spider and the fly, where the fly is drawn into the spider's webs, Joe Hartzfield unfortunately was drawn to the defendant and he got caught in her webs. Defense counsel made a lot of promises to you in open that were not fulfilled. There is no evidence, other than the defendant's own words, that she was actually under the influence of narcotics. In fact, the evidence is to the opposite. There's actually no evidence that his mismanagement of diabetes led to this heart issue that killed him. The statement that Joe's family had no evidence that she did this. Your family member is desperately trying to leave a woman who you know killed her fiance, who you know, because of her own words, that she's being investigated for a murder for hire, that you know, you have watched the violent swings in her communicating with you. And you know that your son and your brother is scared for his life. You know his worst fear. And you know he's hospitalized for that fear coming to life. And you know that the doctors who are treating him are suspicious of the same person you are, but they had no evidence. Defense counsel told you that the evidence was going to show that Joseph Hartzfield suffered a stroke, and in fact, you heard definitive testimony that that's not what happened to him. Defense counsel told you that Detective Rocks made the decision to bring her to court without any investigation, and you saw the exact opposite. You heard from Detective Rocks that she poured through the voluminous records in this case. You saw how precise she was on the stand. You knew some of the people that she spoke with in this investigation. And to call this no investigation is an incredible mischaracterization. To say that we don't know the who, the where, the when, it's just a gross mischaracterization of what you saw play out during this trial. If the defendant wanted to kill her husband, that she held a lot of contempt for, How would she do it? What is the way that provides the best defense for her? The most obvious one. And had it happened somewhere else, had it happened with a different family, she probably would have gotten away with it. But Joe's family was paying attention. The medical staff was paying attention. Detective Rocks was paying attention. Sarah miscalculated who she could do this to and where she could do it. Think back to what defense counsel has tried to draw out of witnesses when things don't matter. Think back to the second witness, Joe's sister, Jeannie Hartzfield. Think back to his mom. What was he fighting with them about? What type of diabetes Joe had? When he knew the medical records were very clear. What was the point of that? That Joe should have been low whenever every documented thing says that he ran high? The defendant thought she was the smartest person in any room and that no one could catch her and that she was going to get away with it because that's what she's always done. When defense asked the doctors, when I asked the doctors how many times they have had an insulin overdose, and then how many times they'd seen someone die of it, what was their answer? This is not something that people in this country, with the medical care that we have, that have lived with this condition for this long, die from. It is a statistical problem with how she killed him. It's a practical impossibility based on how he treated his own diabetes and how he died. Blood sugars are easy to fix. You heard this repeatedly. This is something that was throwing them off in the hospital because this is not how a body should react. If you accidentally administer too much insulin to yourself when there's not the intent to kill you, when there's not the waiting and watching you die of it, this is a treatable thing. But that's not what got to happen. That's not what happened for Joe. Because it wasn't an accident. It was the defendant making sure he got enough insulin in his body that he couldn't recover. Defense counsel wants you to focus on the fact that Joe had uncontrolled diabetes, when in reality, that uncontrol was Joe being high. And you heard his fear, his terror of being low. That was intentional on his part. He didn't want to risk being too low. But defense counsel wants you to focus on the uncontrolled part, because that much better fits their narrative of really Joe just did this to himself. But you saw the Dexcom readings. You read the medical examiner's determination. You heard the testimony from the doctors. This was something that happened to him, not because of him. And what should you make of the people that came and testified about their experiences with the defendant? Is every person in Sarah Hartzfield's life just trying to conspire against her? Or does it show statistical impossibility? I told you from the beginning, and now we're here, you've seen it, she's a performer. Another well-timed tear, another look over her shoulder to the camera, another carrying of her prop that she forgets sometimes and doesn't seem to touch. unless she knows someone's watching. It's showmanship for her. Another fly caught in her web. It is really, really rare to encounter someone of this nature. And for the good of the community, for the good of the world, you 12 have to form an opinion. You have to do something. For far too long, too many people have known and have done nothing. You know what she did. There are people who didn't have faith in her being held accountable because she's really slippery. She's really effective at making a very attractive web. And she's good at tangling people so tightly into this web. But you are ready and you have the opportunity and the duty to right this wrong. You can fix what other people have failed to do. You can stand up and you can say, enough. Enough. These are the elements. These are the only elements that the state has to prove to you beyond a reasonable doubt. And we went over these in voir dire. I don't have to prove, as defense counsel continually asks, I don't have to prove how she did it. I would love to know. I would love to know how she did it, but that's not one of my elements. Did she intentionally or knowingly cause the death of Joseph Hartzfield? I don't have to prove that she's not a likable person. I don't have to prove that he is a likable person. I don't have to prove why she did it. Those are my elements that the judge just read to you in your charge. And if you find that I've met these elements beyond a reasonable doubt, and you vote anything other than not guilty, you are holding me to a higher burden, and you are violating the oath that you took. You have heard all of the admissible evidence at this point. What I say, what defense counsel says, not evidence. It's obvious that there have been things that the court has ruled are improper for you to hear. The only thing that you can consider is the evidence that came from that stand and the evidence that's been admitted in trial. And that alone is enough to prove to you that this defendant committed this act with that intent. And you know where she did it? She did it right here in our home. She did it in Chambers County. For a moment, I just want to go over the jury charge with you. The most important part of the law is on the first page. A person commits the offense of murder if she intentionally or knowingly causes the death of an individual. Those are my elements. And you heard about the law regarding extraneous offenses. And you can consider that if I've met that burden as to those offenses beyond a reasonable doubt. Some of you may think, yep, that one's proven. Some of you may think, I'm not sure on that one. That's an individual choice. What must be unanimous is your verdict of guilty. That page, I would submit to you, is the most important. And that's page 8 of the jury charge. I can't tell you if she put the needle in him herself, or if she grabs his hand and uses his own hand while he's drugged by her drugs when he's unconscious, and she uses his own hand to do it. I can't tell you that, and there's a reason I can't tell you that. Because murderers hide how they murder people generally. But you get to use your reason and your logic and your common sense. And you also get to know that that's not one of my elements that defense counsel wants to hold me to. Defense counsel would have you believe that we're here today because a rogue detective performed a shoddy investigation and the state, the government, has railroaded an innocent woman. But we're here today because a woman, the defendant, murdered her husband in cold blood. That's why you have been summoned and you have sat through testimony and you have paid attention, and now is your call. And I think most of you probably know where you are. I've watched you pay attention. You can look at the evidence, of course, but when you go to the back, I would recommend that you pick a foreperson and you take a quick poll to see where you are. Some of you are probably already there. Some of you may want to look at certain things. You can request some of the evidence, you can request all the evidence, or after your poll, you can say, actually, we're good. I'm going to sit down for a moment, and defense counsel is going to be able to talk to you, and I want you to pay attention to what he says. And I want you, again, like I said in open, lean in and pay attention to what he's asking you to focus on. He is a skilled attorney. He is really, really good at his job. So don't fall into that web. Don't fall into that trap. When he's asking you to look at the whole and not the whole picture, lean in and see what he is arguing to you. What he tries to convince you is an element when it's not. Listen to how he tries to make the pieces fit that don't belong. And remember what your job is. Thank you.
Mr. Darwin? Anything else from the state that should be done? All right, thank you. In taking notes of the information I received today, I read all the letters that were submitted to the court from both sides prior to court today. I've fully studied out the statement in advance of plea. I also went over my notes from the preliminary hearings in this matter to make sure my memory was correct.
And Your Honor, just briefly, I apologize. We would be asking for a continuous protective order.
I've already got that in my notes.
Perfect.
All right, thank you. The court cannot add to what was said by Mr. Restelli's family members today to describe the type of person that he clearly was. As time passes, I hope that his family will be able to only recall the good memories that you have of him, and that you'll be able to put behind you the tragic events of July of 2024. I'm sure that will take time, but I hope that can occur. Ms. Restelli, what struck me in the numerous statements in your letters of support that I received was that you quote-unquote loved your children. That's simply not true. Your selfish actions show that you didn't love your children at all. You made them victims. And let me be clear, your children are victims of your actions. They'll be lifetime victims of your actions, and they deserve to grow up without you in their lives. Your actions the day after the events of July show how callous and uncaring you were towards your children and what you did to their father. You tell me in your statement of advance of plea or your pre-sentence report that you wanted to back out of the plan to kill your husband. Yeah, hours after their father was killed, you were preparing for a date, according to a friend of yours from this court. And you were showing off the scene of a crime to those friends like it was a trophy. When you received condolences from a friend of yours from Discord, you said, quote, "It's okay, I'm happy." I simply do not find at all credible your claim that you wanted to back out of the plan to kill your husband after 5 p.m. on the events of July 2024. As Mr. Brown pointed out, the record is clear and unambiguous. You still had ongoing telephonic communications with your husband before the events that led to his death that night. But more importantly, you had more than just hours to do something about that. You had days to stop your family's plan to kill your husband. But you elected not to do anything. It's clear to the court that your statements and actions or lack thereof in July 2024 was not of somebody who wanted to back out of the plan that you've admitted to in your statement in advance of plea, but of somebody who was willing to go forward with it and was happy that the event and the plan was successful. I think it's also important to remind you, as the state pointed out, that you had also entered into a plea deal regarding domestic violence, physical domestic violence against Matt. And there's no record that he ever committed any domestic violence against you. Indeed, it struck the court in our preliminary hearings that you repeatedly told a divorce attorney in the state of Utah that he never physically abused you. So you're not a victim, you're the perpetrator of incredible harm of domestic violence to your children and, of course, to your husband. With those brief facts in mind, I'm going to proceed for sentencing. I'm going to order restitution. There's a stipulation to $2,500 at this time. Further restitution is to remain open as allowed by statute. It's required by state law. I'm going to order a $53 court security fee for each count. Fines and fees will be sent to the Office of State Debt Collection. I will waive the fine in this matter. Any assets that you have should go to your children for their support and the restitution for them. I am going to enter a continuous protective order. That means you can have no contact with your children directly or indirectly. And if you violate that, new felony charges can be brought against you. And by statute, the presumption is that they would run consecutive to your current sentence. As allowed by statute and as required, I will give you credit for time served, which the parties believe is 316 days at this time. I do know that both the state and your attorney have discussed that your offer is based upon your willingness to cooperate with law enforcement. That was reflected in the plea deal that was offered you, which included the stipulated sentence. That doesn't, however, change what you did and how you did it, or what you did during July of 2024 to your husband. For the family, I do need to point out that we have an indeterminate sentencing system in the state of Utah. I imposed a range, and the Utah State Parole Board will ultimately decide how much time Ms. Restelli will serve in prison. As to count 1, murder, a second-degree felony, I impose a statutory maximum of 1 to 15 years in the Utah State Prison. As to count 2, conspiracy to commit murder, domestic violence, also a second-degree felony, I impose the statutory maximum allowed by state law of 1 to 15 years in the Utah State Prison. As to count 3, felony discharge of a firearm, domestic violence, a first-degree felony, I impose the statutory maximum, according to state law, of 5 years to life in prison. Counts 1 and 3 will run consecutive to each other. By stipulation, count 2 will run concurrent. Do note, Ms. Restelli, you have 30 days to appeal the sentence. On an appeal, if you qualify and request the same, an attorney will be appointed to represent you. Any questions from the state?
No, thank you.
Any questions from the defense?
None.
All right, thank you, ladies and gentlemen. This court will be in recess.
Thank you.
All rise. Thank you. You may be seated.
I'm so very deeply sorry for the pain that I've caused. I understand that my apology will never be enough to heal the hurt that Matt's death has caused and continues to cause. He didn't deserve it. If I had the power to bring him back, I would. I know that my actions directly caused Matt's death. And for my part, I realized the devastation I caused. I didn't think about the pain it would cause. My heart breaks for his children, his family, his friends, and his community. At this point, the least I could do is speak the truth on what happened to give Matt and his family the justice they deserve.
That's it, Judge.
Anything else from the state that should be done? All right, thank you. In taking notes of the information I've received today, I read all the letters that were submitted to the court from both sides prior to court today. I've fully studied out the statement of advance of plea. I also went over my notes from the preliminary hearings in this matter to make sure my memory was correct.
To judgment of this court, you are guilty. In count 2, a jury of your peers having found you guilty of first-degree murder and the perpetration of a felony, it's a judgment of this court, you are guilty. In count 3, a jury of your peers having found you guilty of first-degree murder and the perpetration of a felony, it's a judgment of this court, you are guilty. In count 4, a judgment of your peers having found you guilty of aggravated child abuse, it's a judgment of the court, you are guilty. In count 5, a jury of your peers having found you guilty of aggravated child neglect, it's a judgment of the court, you are guilty. In count 6, a jury of your peers having found you guilty of tampering with evidence, it's a judgment of the court, you are guilty. In count 7, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 8, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 9, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 10, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 11, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 12, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. Count 13, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. Count 14, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 15, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 16, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 17, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 19, a jury of your peers having found you guilty of abuse of a corpse, it's a judgment of the court, you are guilty. And in count 20, a jury of your peers having found you guilty of failure to report a death under suspicious, unusual, or unnatural circumstances, it's a judgment of the court, you are guilty. In counts 4 through 20, the jury did not assess a fine, so there will be no fine assessed in those counts. Now we'll be in recess about 15 minutes.
Thank you. Court stands in recess.
states present, defendant is present with counsel. Ladies and gentlemen of the jury, have you reached a verdict? Okay, and are you the foreperson? Yes. If you would hand the verdict form to our court deputy, I'm going to review it, make sure it's been filled out completely. Believed to be in proper order, and I'll have Madam Clerk publish the verdict. Ms. Agee, please rise to accept the jury's verdict.
In the Circuit Court for Escambia County, Florida, State of Florida Plaintiff versus Sheila, Annette, AG, Defendant, Clerk number 1723 CF 003379B, Division A, verdict. We, the jury, find as follows as to the count charged in the indictment. Count 1, guilty of principal to first-degree murder as charged. So say we all, this 6th day of August, 2025, Juror Carpenter, foreperson.
Would either party like the jury polled?
Yes, Your Honor.
Okay. Madam Clerk's going to poll you. She's going to ask you a question. If you'll just respond to her question.
Juror Carpenter, is this your individual verdict as well as the verdict of the jury as a whole?
Yes.
Juror Quadrosi, is this your individual verdict?
Yes.
Juror Edwards, is this your individual verdict?
Yes.
Juror Potter, is this your individual verdict?
Yes.
Juror Ram, is this your individual verdict?
Yes, ma'am.
Juror Radat, is this your individual verdict?
Yes.
Juror Prokarski, is this your individual verdict?
Yes.
Juror Murray, is this your individual verdict?
Yes.
Juror Dunlap, is this your individual verdict?
Yes.
Juror Olson, is this your individual verdict?
Yes.
Juror Blake, is this your individual verdict?
Yes.
And Juror Alden Coe, is this your individual verdict?
Yes. Thank you. Mr. Ackman, if you, Ms. Agee, would like to have a seat, I'm going to read the final instruction. This is the last instruction from our Supreme Court before we release you for the evening. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. I do want to take this opportunity to thank you for your service on Monday, yesterday, and again today. You gave 3 days of your time to help us resolve this case, and we certainly appreciate the time and consideration you've given to this case and your willingness to serve. I am going to reintroduce the attorneys. We have Ms. Bridget Myers-Jensen. She's the Chief Assistant State Attorney here in the First Judicial Circuit, and Mr. Alvin Trey Myers, and he is the Deputy Chief Assistant State Attorney here in the First Judicial Circuit for the state of Florida, and Mr. David Ackerman, who's in private practice here in Pensacola. And I always like to reintroduce them in case you wish to reach out to them. They won't reach out to you, but if you'd like to, I know when I was trying cases, I did on a few occasions have jurors contact me, and it was helpful to understand, what the discussions were in the jury room. But again, that's up to you. You're not required to do that in any way, and you can find their contact information online. And again, this will count as your jury service for the year. And we again appreciate your hard work and time and consideration this week. So on behalf of myself, the Assistant State Attorney, Defense Attorney, Defendant, we thank you. You are now free to go, and our court deputy will get you checked out. And Have a nice rest of your week. Thank you.
Your Honor, based on the jury's verdict, we should proceed to sentencing today. Ms. Brooklyn's mother is here, and she would like to speak before the court enters sentencing. You want to come forward this way? Yes, ma'am. Ma'am, if you'll raise your right hand for me.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, nothing but the truth?
I do.
Okay, if you'll just state your name for me, ma'am.
Cornelia Sims.
You have something to read for the judge?
I do.
Okay, please go ahead.
Webster's dictionary defines a mother as a woman who has given birth to a child, provided an egg for a child, or who has legally adopted a child. My definition of a mother is a selfless, loving human who often sacrifices many of her own wants and needs for those needs of her children. A mother makes sure that her children are equipped with knowledge, skills, and the abilities to make it as a competent human being. It has been 1 year, 11 months, and 25 days since my daughter, Brooklyn Taylor Dior Sims, was tragically taken from me. I miss my daughter. Casey lost her mama. Casey lost her daddy. Casey lost her other grandmother. When I say my granddaughter does not understand, and I don't know if she ever will, what happened on August the 11th, 2023. When I say this, I'll never be the same. Try to go on for Casey's sake, but I'll never be the same. I want to thank you, Trey, Ms. Bridget. Thank the jurors. That today, Justin for Brooklyn Taylor Sims has been served.
Can I ask you one more question?
Yes.
How's Casey doing now?
She's thriving. She's getting big. At the time of the incident, Casey was 15 months. October, Casey will turn 4. She's just like Brooklyn. When I say identical, she looks like her from head to toe. She's her mom.
Thank you.
You're welcome.
Your Honor.
Anybody else that wanted to be heard?
I don't believe so, Your Honor. Based on the jury's verdict, though, there's only one lawful sentence, Your Honor, and that's adjudication of guilt, life in state prison without the possibility of parole. I believe the court costs are $518, and that's all the state has, Your Honor.
I believe her credit was 722 days.
Judge, may I, my client would like to say something.
Yes, sir. Just 1 second.
Your Honor, I would like to say that Ms. Sims is 100% correct. I failed as a mother. I failed as a friend. And I failed as a grandmother. And it was something Brooklyn didn't deserve. There's no way I can express my sorrow to you. And I'm sorry, I don't ask for forgiveness. I don't ask for forgiveness. And I don't ask for forgiveness when you need a PP. But I want to let you know you are a great mother. You are a great mother. You are a great grandmother. And you were a great friend. And I let you down. And I apologize from the bottom of my heart for letting you down. And I hope you strive. And I hope Casey strives. And TT, I hope you and Aiden strive. And I'm sorry from the bottom of my heart. And thank you, Ms. Jensen, and thank you, Mr. Trey. And thank you, Mr. David. And I am so sorry to my family. I love y'all. In Your Honor, I apologize to you as well. Thank you.
Thank you, Ms. Agee. Mr. Ackerman, anything else from you, sir?
I'm sorry.
I said, was there anything else from you?
No, Your Honor.
Okay.
All right, fine.
Based on the jury's verdict finding you guilty as charged of principal to first-degree murder, I will adjudicate you guilty of that charge, sentence you to life in the Florida Department of Corrections without the possibility of parole. I believe she has credit for 722 days. Any objection to that amount of credit? And she'll be given that credit. I'll impose $518 in court cost. Madam Clerk, there's no other required cost, correct? All right. And this is the judgment and sentence of the court. You have 30 days to appeal. If you cannot afford a lawyer, one will be appointed to represent you. And all financial obligations will be reduced to judgment lien. I'll remain to observe Ms. Agee get fingerprinted, but otherwise, court is adjourned. Maybe go check and make sure. I'm fine. If y'all need to step back with me, you can.
See you tomorrow, Judge.
I'll see you in the morning. Okay.
All right, thank you. Going back to the request to score OV5 at 15. The court knows that there has to be a rational basis to assess the 15 points. The court knows that actual evidence of or proof of that a victim's family member has sought or received or medical treatment is not necessary. But having gone back and looked at the letters that were submitted and looking at the language of those letters, they include phrases such as, "We're not only burdened by grief." The fact that there is one side of the family who had to learn of Lila's death from social media, online posts, and from other friends and family members seeing these things on social media. Certainly that might create some psychological injury that would afford some type of therapy or other treatment. I know in some of the letters it indicates that family members are having reoccurring nightmares where they can see Lila trying to fight off her mother, crying, begging her mom to stop. There's language in the letters that include, "This loss has left permanent scars on my family. It has affected every part of our lives, emotionally, physically, and spiritually. What hurts most is knowing how she suffered. This is painful. I live every day with a hole that nothing will ever fill. Even through my grief, I say this with complete honesty. But I do have righteous anger." Certainly, that type of language displayed within the victim impact statements from the family members, as well as what's been placed on the record through the impact statements that were given orally today, certainly support 15 for over 5. And so the court will score it, and I note the defense's objection for the record. If my math is correct, that would make the total OVs 125.
That's correct, Your Honor.
Does that change the OV level?
It does. It changes it to a level 3.
And it changes the sentencing guideline range to?
180 to 300 to life.
The court has had an opportunity to review the contents of the pre-sentence investigation report through motions that have been filed in this case from the prior attorney. I've had the opportunity to see the most horrific photos of an 8-year-old girl I have ever seen in my entire life. It was horrific. She was unrecognizable, and it is unimaginable what Lila went through. It is unimaginable that she sat for 2 to 3 days in the condition that she was in, and nobody thought it prudent to get her the proper medical attention that she needed. She had significant swelling, bruising from the crown of her head to the soles of her feet, and everything in between. Multiple wounds to her face, to her head, bruising. Certainly something more than falling down the stairs. She was brutally attacked by the individual that was supposed to love her, to nurture her, to care for her, to protect her, and to guard her against any and everything. But instead, the way in which she chose to guard her, protect her, is to go to Rite Aid and get diapers for an 8-year-old because she couldn't afford to get out of bed to use the restroom. Court even read that she was going to take her to the hospital, because her insurance was back on. Whether she had insurance or not, Lila was certainly in need of going to the hospital and receiving medical attention. Whether Ms. Duperon had to pay for the rest of her life for that medical bill because there was no insurance, certainly Lila needed to go to the hospital. When Ms. Duperon knew that she couldn't even lift her, she should have known that she needed to go to the hospital. Lila couldn't even do anything other than to sit up in bed, couldn't get out of the bed, but somehow Ms. Duperon thought that she seemed to be getting better. So instead, as I said, she purchased diapers, baby wipes, and a Thermopack wrap, and meal replacement shakes, when what she really needed was the intensive care unit. That's what she needed. Then you have the boyfriend, AKA the stepfather, who indicated that if it was his blood child, he would have called the cops. But since it wasn't, not my problem, I don't know what to do. What he should have done is to pick up the phone and call 911. Better yet, grab Lila up in his arms, get in the first thing smoking, and get to the hospital. That's what he should have done. But he checked on her and went to work. When reading the family members' letters and listening to what was said today, they certainly took the words out of my mouth in terms of the notes that I had, because the ongoing theme in my notes is that she was failed on multiple occasions. She was failed by the live-in boyfriend who didn't seek to get her medical treatment, and she was failed by her mother. But Lila should be remembered as the well-behaved, fun-loving, innocent, light-of-the-world, bubbly girl that she was, and not for anything else. And so this court believes that Lila is now in a place where she is loved for, where she is cared for, and where no one else will have the opportunity to fail her. The court notes that Ms. Duperon, and you can stand, entered into a sentence agreement with the people of the state of Michigan, whereby she is to serve 28 years to 50 years in the Michigan Department of Corrections. And the court is going to abide by the sentence agreement you entered into with the people of the state of Michigan. There is jail credit for 499 days. And there is a motion from the people to dismiss counts 1 and 2 pursuant to the sentence agreement. Is that correct?
That's correct, Your Honor.
And I imagine there's no objection from the defense.
No, it's not.
Ms. Duperon must pay a crime victim assessment fee in the amount of $130. Court costs in the amount of $300. Attorney's fees in the amount of $200. $68 in state costs. You may file an application for leave to appeal your conviction and sentence. And if you choose to do so, you must do so within 42 days. If you cannot afford an attorney, the court will appoint an attorney and furnish the attorney with portions of the record and transcript necessary to handle your appeal. This request must also be made within 42 days. You're currently receiving a document. You'll need to initial and date. It's just acknowledging that I've given you your appellate rights in this matter. Is there an acknowledgement for the record?
Yes, there is. And for the record, Your Honor, we are tendering back to the court.
Thank you. Ms. Duperon is remanded to the Michigan Department of Corrections.
Thank you, Your Honor. Thank you.
Don't do that. Can't do that. You can't do that.
No, it's over now, so
Presenting her side, and that is not the truth. Maricopa County is a court of innovation. We virtually screened hundreds of jurors, and we kicked off jurors from service that had ever even heard of Lorie Vallow. So when she says that she couldn't get a fair trial in Maricopa County, that is not the truth. Your cases involved 24 separate jurors who deliberated and reached verdicts on these two cases. They represent a broad cross-section of society, which means these two verdicts represent the decisions of our community, not the view of a single person, not the view of a single prosecutor, and not the view of a judge. The collective decision-making of juries helps to reduce individual biases and errors in judgment. 12 jurors in the first case unanimously agreed that proof beyond a reasonable doubt established you conspired to kill Charles Vallow. And 12 separate jurors in the second case, again with no prior knowledge of you whatsoever, no knowledge of your notoriety, unanimously agreed you conspired to have Brandon Boudreau killed. Many people have asked why the state bothered to extradite you and bring you to Arizona, given the sentences that you received in Idaho. Trials are not just about seeking accountability or punishment from those who have committed crimes, but to give the victims of crimes justice and acknowledgement of the impact of being a victim. Justice demands not only recognition of the pain inflicted, but a firm response that upholds the dignity of every victim harmed by the actions of someone who has shown blatant disregard for humanity. You've left a wake of destruction stretching from Louisiana, across Texas, Arizona, up to Idaho and back again. Anytime a person victimizes a single individual, the ripple effects of their actions extend far beyond the immediate harm. And you have not victimized just a single victim, but many. You've shattered lives, you've undermined trust, you've sowed fear in the hearts of many. I can't imagine what Brandon and his family went through for those months, hiding, Charles's family wondering who's next. Is someone coming for them? Jenny said a lot of the things I was already going to say to you, Brandon. I'll just touch on a couple of them. I had wondered during the trial whether you suffer from survivor's guilt, and she confirmed that for me today. I also remember looking at you in the back of the courtroom trial, and just, you have this look about you of a wounded individual. I hope you can heal someday. To Charles's family, I just wanted to share with you that I'm sorry for your loss. Charles seemed like a great all-around guy. One of the exhibits that was put up during the first trial, I noticed something. He and I share the same birthday. So I'll remember him on my birthday. I've seen many, many cases in my career where someone faces a long prison sentence for what amounted to one split-second bad decision. You are not that person. The amount of contemplation, calculation, planning, manipulation that went into these crimes is unparalleled in my career. Your powers of manipulation are profoundly destructive, one that undermines trust, distorts truth, and can erode the very foundations of healthy relationships and society. The impact of your manipulation has been devastating, insidious, and far-reaching, and perhaps still unknown. One can't help but wonder if Alex died as a result of the extraordinary burdens that you placed upon him. No one will ever know. You preyed on the vulnerability of those around you, JJ, Tylee, Alex, Melanie, others. And today I heard about Colby. You specialized in exploiting the empathy and goodwill of others, turning those virtues into tools of control and harm. I think that over time, as a result of being subjected to your manipulation, those people lost their sense of self and their ability to distinguish truth from falsehood. In the face of such profound damage, a long prison sentence is not merely a punishment. It is a necessary affirmation that our society values justice, protection, and the sanctity of human life. You just referenced a Bible verse or a verse recently about the prisoners shall go free. That is not a literal verse. That is a verse about people that accept Jesus can be in prison and they will go free when they die and go to heaven. But it will take an act of God for you to go free. In short, you should never be released from prison. Eventually, the camera that you seek out so much, the media requests, will lessen over time and you'll fade into obscurity. The state has requested that I find additional aggravation. The court does find that in CR 2021-001704, the offense was committed in the expectation that you would receive pecuniary gain. In the CR 2022-001242 case, the court finds the emotional harm suffered by Brandon and his family to be immeasurable. The sentences on those aggravating factors alone will be justified. The state also asked to find an aggravating factor of a prior felony conviction within 10 years of this offense. However, I'm hesitant to do that just because of the way that statute reads, that the offense had to be committed before the date of the offense on these two crimes, which it wasn't. So the court will decline to find that aggravating factor. However, as I said, the substantial amount of harm to the victims and the victim's family, emotional, financial, and otherwise, are immeasurable and justifies consecutive sentences. Ms. Vallow, what's your position on Ms. Woodcock's restitution request of $8,949.52?
I just received it from my advisory council, and I'd like to get a chance to look at it. So I know that the restitution from Brandon hasn't been turned in yet, so we'll look at that, and I can discuss it with my advisory council.
Would you want to waive your appearance for a restitution hearing in the future and have your counsel handle that?
I don't see why I couldn't appear by Zoom.
I think my request would be just to leave, not waive her appearance at this time, but if there ends up being some restitution hearing, I can reach out to her and decide if she wants to be here for that.
I'm not going to have her extradited from Idaho for a restitution hearing if she wants to appear, so that's my issue here. She may be able to appear virtually, I don't know.
Because at this time, we don't have the restitution from Mr. Boudreaux, so.
All right. I'm going to set a status conference regarding restitution as to Kay Woodcock. We'll set that in a few moments. If you agree to it prior to that date, we'll vacate it. If not, we'll have to talk about setting a restitution hearing. The court will also, at the request of Brandon Boudreaux, issue a lifetime injunction that prevents you from having any form of contact whatsoever with him for the rest of your life. The court will also issue an injunction on behalf of Susan Vallow, Kay Woodcock, and Jerry Vallow that likewise prohibits you from having any form of contact with them for the rest of your life. You'll be served with those injunctions later today. In each case, it's ordered that you pay a $9 victim compensation fund assessment, a $20 probation assessment, a $2 victims' rights enforcement assessment, and a $13 criminal penalty assessment. Although it's largely symbolic, the court's going to impose the maximum fine allowable for each case. It's ordered that you pay a $150,000 fine plus a 78% surcharge on each case. Those total fines on each case is $267,000. I know the law says that you can't financially benefit off your crimes, but in the event that somehow you did, those restitution amounts or those fine amounts are out there that can be paid. As to count 1 in CR 2021-001704, The court orders you to be sentenced to life in prison with the possibility of parole after serving 25 calendar years. This sentence would run consecutively to the District Court of the 7th Judicial District of the State of Idaho in Fremont County, case number CR 22-21-1624. As to count 1 in CR 001-242-001, it's ordered that you be sentenced to life in prison with the possibility of parole after serving 25 calendar years. That sentence also, due to the number of victims you've created in the two cases, the immeasurable harm you've inflicted on many, it's ordered that that run consecutive to CR 2021-001-704. Because these sentences are consecutive to one another and consecutive to the Idaho case in which you are currently serving a sentence, you're giving 0 days credit for time served. You have the right to appeal from the orders of the court and to have a lawyer represent you. If you cannot afford a lawyer, one will be appointed for you. If instead you want to represent yourself in your appeal, you must file a written waiver no later than 30 days after the filing of your notice of appeal. If you cannot afford copies of the necessary records and transcripts, they would be provided for you at no cost. If you want to appeal, you must file a notice of appeal within 20 days of today, or you lose that right. If you want to petition for post-conviction of relief, you must file a notice within 90 days from today, or within 30 days after the appellate court issues a mandate affirming the judgment and sentence in your direct appeal, whichever is later, or you would lose that right as well. It's ordered remanding you to the Custody Department of Corrections effective today to carry out those sentences. We're at recess.
Do that. Let's go. Everyone out now.
Ladies and gentlemen, welcome back. I understand the jury's reached a verdict. Is that correct? All right, and have you written the verdict on the indictment, signed it as the foreperson, and dated it?
Yes.
All right, if you would please hand it to the bailiff. All right, I'll ask the clerk if she would please publish the verdict.
Indictment number 2021 GS 2601191. The State of South Carolina, County of Lorie versus Megan Marie Jackson as to the charge of murder. We, the jury, by unanimous consent, find this defendant guilty. Signed by foreperson Jeffrey Roberts, dated June 17, 2025. Ladies and gentlemen of the jury, if this is your verdict, please so signify by raising your right hand. Thank you.
I let the record reflect that all jurors raise their right hand. Any polling of the jury by the defense?
No, sir.
All right.
Sitting in a plot that doesn't belong to them. At some point there might be, but I doubt it will be.
Although no person is asking for probation, the defendant is statutorily ineligible for probation, pursuant to the dictates penal section 190 and 190.2, and consequently probation is denied. As counsel has pointed out, I do have discretion under penal section 654 as to which count to impose sentence. Listening to the evidence in this matter, I do find that the defendant was the mastermind in Baker did not have the intelligence to plan such a brutal, well-thought-out slaughter. Defendant was the prime mover in this execution of a human being, and consequently, I am utilizing my discretion to impose the more serious of the sentences. Although this is not before me, Penal Code Section 1385.1 states that a court does not have discretion to strike a special circumstance that is found true by the jury. The legislature has, in its wisdom, had such bills before it that would take away this lack of discretion. For purposes of any future legislature, I must state now that if I had the discretion to strike a special circumstance, in this particular case, I would not. For the crime which has been convicted in count 1, of violation of section 187, subsection A, murder in the first degree, with special circumstances having been found true pursuant to section 190.2, subsection A, subsection 1, and 190.2, subsection A, subsection 15, we sentence the court as follows. Probation is denied for the reasons I have stated. Defendant is sentenced to state prison for the term prescribed by law, which is life imprisonment without the possibility of parole. Yes. As to count 2, violation of section 182, subsection A, subsection 1, conspiracy to commit murder. Defendant is sentenced to state prison for the term prescribed by law, which in that case is 25 years to life. The sentence in count 2 is stayed pursuant to Penal Code Section 654. Said stay to become permanent upon the successful completion of the sentence in count 1. Then is levied a $10,000 restitution fine pursuant to Penal Section 1202.4, subsection B. An $80 security fee, which is $40 per count. A $60 criminal court assessment, which is $30 per count. She is to submit a tissue sample for a DNA databank pursuant to Penal Section 296. She is given the following credits of 2,932 actual days, 0 days conduct credits pursuant to Penal Section 2933.2. This time, ma'am, I have to advise you that you have the right to appeal to the Court of Appeal from the judgment of this court. You have, if you wish to appeal, you have 60 days to file your notice of appeal. It must be filed in this court and not in the Court of Appeal. It must state that you are appealing, what it is you're appealing from. It must be signed by you or your attorney. If you appeal, you have a right at no cost to you to a transcript of the trial court proceedings that's provided by the California Rules of Court. If you appeal and you do not have the money to hire an attorney, one will be appointed for you free of charge by the appellate court. You understand your appellate rights, ma'am? Very well. We are done.
Your Honor, could I ask one additional thing? The court has any discretion for asking that the court recommend that she be housed in CIW, which is the closer state prison facility for the benefit of her children who obviously want to continue seeing her?
I cannot tell the Department of Corrections Rehabilitation where to place their inmates.
Thank you.
Thank you.
Okay, all right, thank you. I'm good, I know everything from the trial. I figured.
This is a defendant who is extremely deserving of the sentence of life without parole. I know from past history in our office, perhaps had there been a different administration, I remember a case regarding the Green Widow who did something similar to this, and she received the death penalty. This is one of the most premeditated, calculated, devious murder conspiracies I've prosecuted during my 31 years at the District Attorney's Office. And as this court knows, I have handled numerous cases involving serial killers. This is a defendant who, but for her actions and her decisions, her husband, Fabio Sementili, who gets lost in all of this circus that goes on every time we have one of these cases, he would still be alive today. This was a completely senseless murder driven solely by this defendant's greed and her lust, which we saw on full display during the trial that took place over the course of several months this year, based on her desire to get rid of her husband because he no longer served her purposes, and she needed to have a way to fund her life together with Robert Baker, who she chose over her husband, and whether her kids want to believe it or not, over her children, because they never ever even came up in any of the conversations that she had with so many people who testified in this matter. It's incredibly despicable as far as motives go, because again, without her and her plotting and her planning the murder of her husband, he would be alive today. But then you add to it the lengths this defendant went to in order to conceal and destroy evidence, and how time and time again she got others to do her dirty work for her, including her lover, so that he could get the murder done and she could take a step back and pretend to still be this loving wife, which we all know was a complete act. And once and again, it showed through the admissions that she was caught making in the jail lockup, through the letters about getting rid of her husband and wanting to marry Robert Baker, through the entire complex setup of this time frame for that day, shows a level of sophistication and planning that I rarely see in these kinds of questions, these kinds of cases. There is no question but that this defendant was the mastermind behind the murder of Fabio Cementilli. One only had to listen to Robert Baker's testimony for about 10 minutes before you got the clear picture of who was the mastermind between the two. Mr. Baker isn't smart enough to even follow up his lies with consistency. There was nothing that was credible about his testimony, and the jury so found. In addition to that, we had the testimony from Christopher Austin, and while he was kept out of the center of the conspiracy between the defendant and her lover, Robert Baker, he knew enough that this was being done at her behest. And as I've said from the beginning of the trial, this case was about the ultimate betrayal. This was one that I'm sure Fabio Cementilli never could have imagined in his wildest nightmares was coming. That his wife was literally plotting his murder with her lover. It's an absolute betrayal, not only of Fabio Cementilli, the victim in this case, but of her children, who have been brainwashed by her lies and her deception. And that's their choice. They're adults now. If they choose not to face the truth, that's on them. But we're here to do a job. We've done our job. The jury did their job. And we're here to hold the defendant, the main player, the heavy in this case, responsible for her actions. She used her family, her children, her parents, her sister, to do her dirty work for her, to lie to their father in order to cover up this scandalous affair that she had been having for at least a year, and God knows what else she used them for. She manipulated everybody, all of her friends, all of her family, anybody who came into contact with her for the most minor of things, such as buying a vehicle. We heard about that.
Well, to the family members, first off, I do hope that you have the opportunity for closure, celebrate as much as you can celebrate something like this, but I hope that you do spend this weekend, as you talked about, honoring Todd. And again, hopefully today will bring you some level of closure. Ms. Durmer, you've now had the process that was due to you. You had an extraordinary team of attorneys working on your behalf, not for months, but for years. With ardor, they filed motions and pursued what appeared to be every avenue on your behalf. They brought in experts to undermine and contradict the testimony of the prosecution's experts and to bolster the defense theory of the case. You also had this time around a new prosecution team in this trial and in the years leading up to this trial. From this court's perspective, this prosecution was diligent, thorough, and zealous, but they also played by the rules and worked under the mantra of seeking justice, not just a conviction. All this to say that I am confident, Ms. Durmer, that you received a fair trial. Murder is by its nature a monstrous deed, but the one you've committed is even more gruesome than most. You lit your husband on fire and burned him alive. When he made it out of the house and you had a chance to reconsider your actions, you instead doubled down and ran him over with your car. I cannot fathom the suffering he endured in his last moments of life. And I cannot fathom the damage you've inflicted on Todd's family, his mother, his siblings, now your grown children, his grown children. You lured them out of the house using one of your many labyrinths of lies. They went to the mall and movie at your request, thinking you'd be discussing divorce details with your victim. And you didn't even allow them to say their customary goodbye to their father before you murdered him. Now they live with not only the murder of their father at the hands of their mother, but the fact that had you not convinced them to leave, you may not have had your window, or at least on that date, to commit your heinous acts. Their testimony was clearly difficult, but it was compelling. Your sons displayed on the stand the courage and strength of character often associated with those who have endured significant trauma. I use the word sons loosely, as they clearly do not recognize you as their mother anymore. Suffice it to say that if there was ever a list of all of the things parents should do on behalf of their children, murdering the other parent would not be on that list. This court is to balance punishment, protection, deterrence, and rehabilitation where possible. I'm hopeful you will engage in programming when returned to the Department of Corrections, programming which may or may not provide some measure of rehabilitation, but only a sentence of life without the possibility of parole can protect others from you and deter others from committing like conduct. And only a sentence of life without the possibility of parole can properly punish you for the heinous acts you've committed in burning your husband alive and in leaving your children with that imprint forever. The sentence of the court is life without the possibility of parole. Credit is 3,367 days. I'm showing that mandatory financials have already been paid, so I won't reorder those. And counsel, the judgment will this time state one first-degree murder conviction with the two alternative theories. Is that satisfactory to counsel?
Yes, Your Honor.
Okay.
Like which one?
I'll just put first degree and then put under two alternative theories, either felony murder or premeditated.
Thank you.
Does that work? Okay. Ms. Durmer, you have a right to appeal the conviction and sentence. You have a right to ask for a court-appointed attorney to assist you in that appeal if you're financially unable to afford your own. If you do wish to make the request, you need to fill out the paperwork we're getting you now and turn it back into the court within 42 days of today's date. Bond is canceled. Anything else, counsel?
Nothing further, Your Honor.
No? Okay, here's her. Okay, thank you, everybody.
off of the acceptance of responsibility, the facts that have been presented to me, both in aggravation and in mitigation, as well as reviewing of the law, I can say that this is a very tragic case. There are always options, and I understand why some people are highly favored for adoption and some people are not. I also know that taking care of any child that has special needs is very challenging on a caregiver and can become exhausting and feel overwhelmed. I also know that when you add in any type of mental health diagnosis, when you're a caregiver of someone with special needs, it can seem unmanageable. And I'm not unsympathetic, Ms. Hobbs. I heard Mr. Ozark loud and clear at the attempted times that you've taken for your life as well as self-harm. Also balancing that against what Olivia went through and how she died in the manner of death. There's very rare, I've been doing this for a while, and there's very rare cases where I have a murder case that does not involve a weapon, a physical weapon. And even sometimes hands are a physical weapon. And it's difficult. How do you process that? How do you process someone who says, I want to take responsibility, I understand what I did was not right, and I do not want to go forward with the trial because I am taking responsibility and I'm not making excuses. And you balance that against what the victim went through. And there's different types of punishment. There's some that are deterrents so they would never do it again. There's some that's rehabilitation, which does not apply here. There's some that's retribution. And there's some that's punitive, that sends a message more so to not only the offender, but to the community. And I have to balance all of those of what is best for this case. And having said that, what I'm going to do is I'm going to impose a sentence of a whole sentence, a total sentence for the entire case to life without the possibility of parole. You'll be given credit for the 660 days that you have served, which is credit from the time that you were in custody. Let me ask, this is a question that I like to ask, how many days was she in Marietta before she was transported? Because she was eligible for that as well. The 660 days is only what was here in the cap. Okay, either way.
The detective is actually in the courtroom now, and she advised that she was taken directly from Marietta and booked it to the cap.
Okay, thank you. So it'll be 660 days. That will be the order of the court. Court is adjourned for this matter.
Mr. Crapence, let me start with you. Thank you. I don't think the public understands the stress on the lawyers for both sides of the case. I also don't think the public appreciates the fact that without defense lawyers, there wouldn't be a prosecution. Because in our adversarial system, as much love as the state might get, the defense lawyers seem to get the opposite. Yet you step into those shoes, and in this case, I've seen very capable lawyers working very difficult facts, often without any appreciation. So to the extent that you and Mr. Hunt did a fine job, you ought to at least be publicly acknowledged. So thank you very much for a long career.
Thank you, Your Honor.
The first part of the hearing, when the victims were speaking, was what I expected. A built up, raw emotion of rancor and ill will, and all very understandable and unfortunate. If anything cathartic can come out of today, it might be of the fact that there's some closure, or maybe not forgiveness, not forgetting, but the fact that the process will have worked and people can move on. Whether you choose to accept that or not is yours, as any free person can, but maybe closure helps. There was a reference to this being the worst massacre in the state of Ohio. Well, let's go with something else. To call this the Pike County Massacre, frankly, is condescending to the rest of the good people of Pike County. It's tragic, it's heinous, it's unexcusable, but it's not an indictment of the entire county. That's social media typecasting. The worst massacre in Ohio might very well be 1792 at Canada-Hutton, when 96 Christian pacifists were killed by the Pennsylvania militia because they were Christian pacifists. But each generation has its own people who can prove the depths of depravity of human nature. And that's what this case did. It showed the boundless depravity of people who have no respect for others and their only self-interest in mind. And that's transgenerational. Since the dawn of man, this sort of depravity happens. So the raw emotion you communicated was expected is unfortunate, and I hope somehow you're able to get past it. Not forgetting, but getting above it. But good luck, because what I just asked isn't easy, as you well know. With regard to sentencing, however, the court's not bound by nor has any role in using emotion. The government's responsibility is not to use ill will. We don't have people being burned at the stake as in the medieval days. We don't have public shaming. We don't have a remedy that works. We have analytical guidelines that courts are supposed to follow in imposing sentence. It's not meant to be emotionally driven. So I wipe all the emotion and follow the sentencing factors. The first set of factors are whether the case is more serious or less serious. Clearly, it's a more serious offense for all the reasons stated in the statute. Whether recidivism is likely is the second set of factors. Well, there's a long sentence coming. And I'm supposed to predict the future, which I can't do. So recidivism prediction is virtually impossible. It's backward looking. So I'm just going to find that the risk factors for recidivism are balanced equally against the less likely, because I don't know what you're going to be as a person or who you'll be after your long prison sentence, Ms. Wagner. The fact that you completed 40 or 50 programs might bode well for you, and it might not. So I'm not going to try to predict anything with regard to the future. You need to understand that there's a mutually recommended sentence. If I impose the mutually recommended sentence, then any opportunity you might have to appeal the sentence is waived or given up. Generally, when a person enters a plea of guilty, they give up any rights to appeal the verdict of guilt. So presumably you don't have appeal rights as to your plea. If I impose the sentence today as recommended, then there's no appeal rights on that issue. The only thing that might be left, dare I say it, would be ineffective assistance of counsel, and I don't have any opinion on that. So if I impose a mutually recommended sentence, your appeal rights are waived as to the sentence. Do you understand that?
Yes, Your Honor.
And that's what's going to happen. I lined up the numbers differently than the lawyers recommended, but they come up to the mutually recommended 30 years. So for purposes of the record, with regards to count number 9, complicity to aggravated murder, I impose a 9-year prison sentence. On counts 10, 11, 12, and 13, I impose a 9-year prison sentence. That's an aggravated burglary. For unlawful possession of dangerous ordnance, count 14, the maximum 12 months in prison. For counts 15 and 17, tampering with evidence, 3 years in prison. Count 16, tampering with evidence, 3 years in prison. No sentence on forgery, no sentence on unauthorized use because they merge. On unlawful interception of the oral communication, 18 months in prison. And then for the obstructing justice in count 21, 12 months in prison. And then engaging in a pattern of corrupt activity, 9 years in prison. Mr. Crapence is right to remind me of the recent case of Beatty. I saw that come rolling out first week of December. Maybe that was in my entry 2 weeks ago. with regard to having to follow the mandates. A lot of people might think judges have unlimited reign, if you will, to impose sentence, when in fact we have pages and pages and volumes of rules and case authority on how to impose a sentence. So the Beatty case tells me that there's a mandatory duty with regard to the firearm specifications to impose the maximum 6 years consecutively to each other. So there's a firearm silencer specification that has to be imposed on count 9 and count 22. So there's 6 years plus 6 years is 12. With regard to 9 more years for the aggravated burglary charges, those run concurrently with each other, consecutive to the firearm specification. So we're at 6 plus 6 plus 9. And then finally on the corrupt activity charge, count 22, there's a 9-year sentence, which is consecutive to the 9. So now it's 6 plus 6 plus 9 plus 9. Is my math right, Mr. Craypens? 30 years. The other charges all run concurrently, so that felonies 3 and 4 don't add additional time. It's 30 years in prison as mutually recommended. You're entitled to 2,244 days credit over 6 years. 6 years and 6 weeks. So that comes off your sentence as a matter of law, because past time has to count. With regard to economic sanctions, there's no fine. Your inability to pay makes that impossible, not only in the past but in the future. There's a legal obligation to pay court costs, processing, booking, pay to stay, medical expenses. So all those numbers should be added up and put on your bill. Your ability to pay depends on future economic circumstances, but it's a legal obligation to impose. When you're released, you have to be on supervision with the adult parole authority for at least 2 years up to 5 years. While on post-release control, you have to follow rules, regulations, restrictions on your freedom. If you fail to comply, you can be sent back to prison for up to 50% of the longest term, so that would be 50% of one of the 9s. So the 30 can turn into 34 and a half for additional violations after you're released at the end of 30 years. You have a legal obligation to register as a violent offender. There's a database. So at the time of your release, you have an obligation for at least 10 years to register as a violent offender. Tell the sheriff in the county where you reside, where you live. If you fail to comply, that can be a parole violation, post-release control violation, or a separate felony 5 offense. And the legal duty can be extended if the state establishes just cause to extend it beyond 10 years, which doesn't start running until you're released from prison. Did I overlook anything, Ms. Kneppa? Mr. Craypens?
No, Your Honor. My client has signed an affidavit of agency from the approach.
Thank you. Yes, that's. I'll hand this back to you. You can have the filing done. Further evidence, Ms. Wagner, of how thorough your lawyer is. See it? To the extent that I wasn't bound by the lawyers, I could have gone higher. I wasn't here when this started. The analysis is pretty true. The state needed you. And in fact, you came through with your part of the agreement. Does that matter? Well, morally, that's up to you. Legally, it's a big deal. In my journal entry, there's 2 cases cited that clearly explain the importance of cooperation, the benefits of mitigation. You help the state make the case. Jake helped the state make its case. That wisdom, wherever it came from, was the difference between a much worse outcome that might very well have been appropriate. I understand you didn't go to the 4 scenes. Nobody seems to talk about the fact that you're the only person that could have stopped the whole thing with one phone call. You're standing there with cell phones that people want you to ping to make it look like you're home. All you had to do was call in. Stop the whole thing. The depravity was that you didn't see the moral need to shut it all down. I don't need an explanation, but clearly any decent human being could have done that little bit to save so much. So with the fact that you accepted responsibility and cooperated, I was willing to follow the agreement. You'll see the Anderson case and the Rahab case is cited in the decision. They go back to 2017 case. The Supreme Court made it really clear twice in the same term the importance in the system of having people accept responsibility and cooperate. So for you, that's the only silver lining. That concludes that case. Ms. Wagner, they're going to walk out the side door and move you on. Thank you, Mr. Craven. It's my pleasure to meet you.
Thank you, my pleasure.
Have a good day.
Here. I sat in this trial. I picked up this case. I started down here July 1. I picked up this case. And I did the motion for motion in limine. And I know exactly what I wrote and what I ruled. You can't use other crimes or acts to show bad character or propensity. There has to be clear and convincing. But it doesn't negate the fact, just because I didn't use that event, it occurred. And it was with 2 people there. It was with Mr. Nix and Mrs. Nix. And when I hear today situations and testimony about where the seat was put in the driver's side because Kaylee Nix did it, not Mrs. Nix, Miss Tracy Nix, the defendant, did it, that's inconsistent with the deposition testimony that Kaylee Nix said, and it's also inconsistent with what she wrote in her victim impact statement. Then I listened to her testimony about the juror was sleepy and gave a bottle and immediately fell asleep. And there's a video, and I don't recall seeing that. But I also recall in the trial, they talked about giving the baby a straw and some water in a straw, and that this was a situation where their baby didn't have food and milk. And I went through, and I'm going to come down to this in a minute, but the evidence that comes in, I wasn't there, you weren't there. The only people that were there were Miss Nix, and at the time, we get evidence after the fact, and when we're sitting in the room and we're watching it, it comes in. Like, here's the back seat of the car, evidence 41 that came in. Here's the front seat of the vehicle, 40, where there's wipes and things in a car. And when people go places with kids, they leave objects, thread on the steering wheel, things in the front seat to remind them where they had a child. And I'm not talking about a child that was there. You had an hour-long, 2-hour-long drive. I'm talking a 7 to 9 minute drive. Here's the exhibit 29. It's the back seat of the car. There's evidence everywhere. Then we see the picture of when Nay and them got there. That's evidence 23. I then have a half-empty thing, a bottle, evidence 35. So I see all of that, and I see all the reminders. And then I remember Kaylee and Nix saying that the Lexus, the red Lexus, was equipped with a red rear occupant alert to alert an adult to a child in the back seat. And I know that these cars, Fords, Lexuses, everything has so much weight in the back seat, beep beeps go off. And I hear her saying I didn't have that. But then I read the deposition, taken of Kaylee and Nick's docket entry 201, October 1, 24. Do you know who put the car seat page 32, line 5 to 7? Do you know who put the car seat into the car that day she picked Uriel up at the glass shop? I do not. I do know it was her tendency to put the car seat in herself. Okay, Kaylee answered. She typically, whether I was standing there or not, would pick her up and set her in there. And then I would typically help reach over and strap her in. But a car has sensors, weight sensors, so that, just like my vehicle, whenever I stop and put it in park and turn it off, there's a loud ding that says, check your back seat if there's weight in the seat. And so those are things that I'm aware of that were in a vehicle. So when she put her in there, I do not imagine that I had any other staff assist her in the moment putting her car seat. Did she normally put the car seat behind the passenger or driver's seat? I have her telling me it was in the driver's seat because Kaylee did it, and I have Kaylee saying that it was typically in the driver's seat. And then I have these tendencies and these things that I see that show that there's a baby in the car. And let's not forget that we just left Benfield Brady's. This child was the apple of everyone's eye there. I've been to the Benfield Brady's. I've had lunch there. There's a lengthy video. There's a video of the car in the parking lot. At the end of the day, Kaylee Shock presented this evidence to me through her testimony, her victim impact statement, and her the deposition. The defense has presented to me the witnesses and the evidence. What I know for a fact is Tracy Nix left Euro in the car at 2 p.m. for over 3 hours. At no time during the 10,800 seconds that elapsed did she think 1 second about her granddaughter. Uriel Shock was there for 2.5 hours with her that day, and she just saw her 7 to 9 minutes before, and then she goes to the residence 7 to 9 minutes away. This child, like I said earlier, was the apple of everybody's eye. It captivated, entertained the patrons and the people at Beef O'Brady's, much like a 7-month-old does, a year-old does, a 2-year-old, a 3-year-old does. You know what you're doing with them, and in 7 to 9 minutes, by golly, you know where that child is. And anything to the contrary, and any excuse to the contrary, is just that. I heard and saw the body cam footage along with the interrogation room video of Tracy Nix immediately discovering what happened after she has a grandchild passed away. She was distraught. I don't believe there's a lot of remorse in that about her grandchild's suffering and death. Rather, I see her more concerned with her community image and the death of the child. I want to leave. I want to go away. I want to do this. I want to do this. I want to do this. And I hear today the evidence and the testimony, and I get a little more remorse on that, but is it truly remorse? Yes. Tracy Nix, throughout these proceedings, has contended these acts were involuntary. She couldn't form the requisite intent to commit a crime. Her narrative is that she forgot because of senility or by taking her prescribed mind-altering medications. There's no credible evidence to the court that's persuaded this court to mitigate her sentence as the attorneys have requested. This defendant, like many other defendants facing prison sanctions before, is trying to avoid or lessen a prison sentence once arrested and after a jury finds them guilty. They justify what happened rather than accepting blame and truly evidencing remorse. I have practiced law for 30 years. I've sat on this bench for over 3.5 years. I've met my share of people in the Florida state prison system, the federal system, and I understand that they minimize their conduct and they also don't accept responsibility. And that's how it is. And there's a pile of them down at Hardy Correctional that'll tell you the same stories that I heard here today. The ultimate determination of when we do a case, and I excluded the evidence of the experts on the defense side. It's when you look at whether a defendant is competent to proceed, it's my determination in state court, in a trial court. Under the Dougherty v. State case, 149 Southern 3rd, 672 at 678, the trial court is not bound by the reports or opinion of experts. The defense in this case never afforded nor volunteered Tracy Nix to the state of Florida to have her evaluated by its own experts, so the state of Florida, the citizens of Florida, were denied the right to contest the evaluation and procedures and conclusions of the Tracy Nix retained, hired experts. They all say we're here for our time. They don't come, they come in here, they get paid, they give their opinion. They give their opinion. If it's valid for the defense, they testify. If it's not valid for the defense, they don't testify. I heard this man's testimony. In a competency or an insanity case, the state has the right to contest the evaluation procedures and conclusions of the court-appointed experts. Had she alleged incompetency or not guilty by reason of insanity, the state of Florida and all the citizens would have the ability, the state would have had the ability to hire its own experts to evaluate her mental and physical claims. The state was not afforded that here, And that's why we have a 35-year-old law that says you can't bring in diminished capacity. I ruled on that. I'm not going to revisit that ruling. The state, as a representative body for the citizens of Florida, has a right to a fair determination and meaningful opportunity to be heard to conduct its own review of Tracy Nix. All of her defense experts were hired for their time and to defend her. They had unbridled access to her so they could present their opinions to the court. What I noticed was there was no, what did the MRI findings say? I don't know. I wasn't given that. There are many tests that mental health experts can perform and routinely do perform on criminal defendants to determine if a criminal defendant is falsifying or exaggerating facts or symptoms. There's called malingering. There's no medical records nor testimony presented to this court that she suffers from Alzheimer's, dementia, or senility November 1 of 2022. None of the defense experts have testified they tested Tracy Nix for malingering or confabulation. They simply say, trust us, we are experts. The court declines to do that. In Florida, the term for imprisonment for a second-degree felony is up to 15 years in prison. First degree is up to 30 years. Life is up to a defendant's life. And in a capital case, I can sentence somebody to death if the aggravating factors exceed the mitigating factors. In this case, Tracy Nix has been found guilty of a third-degree felony, punishable by a maximum of 5 years in Florida State Prison. On January 15, 2025, a jury found the defendant guilty of one count of leaving a child in a motor vehicle in excess of 15 minutes causing great bodily harm, but in reality causing death, and not guilty of one count of aggravated manslaughter. I've already gone over what I talked about with the Rule 3.704D9 about the victim injury points. Her score sheet is 44 points. Under Florida law, the maximum sentence I can impose for Tracy Nix is 60 months or 5 years in Florida State Prison. For me, as a trial court, to impose a departure sentence, it's a two-step process under Banks v. State. 732 Southern 2nd 1065 1067. First, I must determine whether I can depart. That is, whether a legal basis exists for the departure sentence that has been established by a preponderance of the evidence. 2, even if a valid and supported legal ground exists to permit a departure sentence, the trial court must still determine whether it should depart and whether a departure sentence is the best sentencing option in a given case. 2 facts the defense argued in their motion to mitigate. 9, that Tracy cooperated with the state of Florida to resolve the offenses she was charged with on November 1, 2022. The court finds that not to be the case here. Tracy Nix did not cooperate. There's no competent substantial evidence that the crime she was charged with was resolved as a result of her cooperation. To the contrary, she investigated it, she went to trial, she didn't enter a plea to count 2, and she didn't cooperate with law enforcement or the state prosecutor. The second ground they sought mitigation is 10, which is an unsophisticated, isolated incident. There's 3 elements that must be proven by the defendant when you raise that mitigation, not 1 or 2. Number 1, Tracy Nix has to prove the court that the offense was committed in an unsophisticated manner. Number 2, it was an isolated incident, and she has shown remorse. All 3 elements have to be proved. You can't prove 1 or 2, all 3. Tracy Nix and her husband had the 17-month Ezra at their home, who died 11 months earlier. That is a fact. That came in every hearing I've been in, and I've heard it today as well. The grandchild Uriel shock tragedy is not an isolated incident. This is the second. The court watched and heard her interview. I do not believe she's showing remorse. I believe she's showing sorrow. It is impossible for a defendant who refuses to accept responsibility for an offense to show remorse for that offense. Sympathy is not the same as remorse. Sorrow is not the same as remorse. What I look at in the Florida statutes, when I deal with sentencing under 921.02, subsection 1B, the Criminal Punishment Code's primary purpose is to punish an offender. Rehabilitation is subordinate to the goal of punishment. Subsection C, penalty imposed shall be commensurate with the severity of the primary offense and the circumstances surrounding the primary offense. The court does not find that the defendant's sentencing proposal is the best sentencing option. Rather, Tracy Nix should spend the next 60 months in Florida State Prison with credit for time served. The trial court is guided by the code, the sentencing guidelines, and the express purpose for criminal sanctions under Florida law, and a Florida State Prison sentence of 60 months is the best sentencing option. The court also finds that she knew how she was feeling on November 1. The multiple videos, some with audios that day, and the testimony of her Bible study, and many friends unequivocally established her awareness that day she is not competent, nor is she insane. She caused Uriel Shock to suffer an agonizing, prolonged death that was avoidable. The court saw all the evidence in the photos. I want to note the diaper bag that was brought into evidence, Exhibit 36, Exhibit 37, Exhibit 38, Exhibit 39, was the most organized diaper bag I've ever seen in my life. And I heard testimony that the child didn't have food, this, that, and the other thing in the beef O'Brady's, and they fed her through a straw. I note that it was an excellent diaper bag. The bottles, food, medicine, and the items were all in quart bags, Ziploc bags. For witnesses to say or allude that Uriel had no milk, formula, or food is hypocritical and untrue. The court finds such testimony by any such witnesses not credible for sentencing purposes. The defense's recitation of their mitigating factors without confirmation by any unbiased expert, in addition to the deficiencies the court found earlier, also fails to establish by a preponderance of the evidence any mitigation that is to be considered by the court today, nor do they amount to competent, substantial evidence for this or any court to justify a sentence of less than 5 years in Florida State Prison. The defendant restrained Uriel Shock in a car seat, and the child was severely injured before she died. There were plenty of signs to Tracy Nix that she had a baby in her car that day and she was responsible to protect it. She failed in her protection of Uriel. I will not fail this state or this community in my duties as a judge to fashion a sentence that I feel is appropriate for these type of charges. You can call it whichever one of the 5 points you call it, but I'm calling it a just and determinate sentence based upon the facts and evidence that I have seen here and heard here and presented today. The court hereby sentences Tracy Nix to Florida State Prison for a term of 5 years of Florida or 60 months with credit for all time served. A $5,000 fine shall be reduced to a judgment lien. The cost of prosecution and restitution will be reserved for 60 days. Y'all can agree on it or we'll have another hearing. She will be remanded under the supervision of the Department of Correction until her term of prison ends. Now I'm going to speak to this community. I'm not from here. I'm from Winter Haven, Polk County. This community needs to move past this case and leave Kayla and Drew Shock alone. Let them and their 2 children live in peace. This family has lost 2 children, Ezra Shock and Uriel Shock. The tragedy of this case is undeniable. A baby's life is over way too soon, and the family has been severely impacted in unimaginable ways. Whenever a child dies, this entire community suffers. This community needs to move forward and start the healing process. I have made a final and determination here. I'm not putting people on probation to be walking around this community to rehash an issue or something to come up. I have sentenced her to 5 years in Florida State Prison. I want this community to move forward. The legislature defined this felony crime. A fair and impartial jury found Tracy Nix guilty, and I, as a circuit judge for Hardy County, have sentenced her accordingly. Ms. Nix, you have 30 days to appeal the judgment and conviction of this court. If you cannot afford an attorney, one can be appointed for you without cost for appellate purposes. Mr. The state, do you have anything further I need to deal with?
Your Honor, to head off an issue, we'll waive cost of prosecution, so we don't have that here.
Okay. Do you want to reserve on restitution? If you don't, you can reserve it, and then you can either agree, disagree, or say, Judge, we're not having it, it'll go away on its own.
Your Honor, we can reserve it, and it'll probably go away on its own.
Okay. Mr. Fletcher, anything further we need to go on?
One thing I have to say as her attorney, May Nix today, and I think I don't know if she's still here, Alex Amanda Fletcher testified there wasn't any car.
I understand. I understand.
Okay, because you said that, I thought you said there was.
You're talking about the car seat?
Obviously, we disagree about the remorse. I'm not going to argue with that. We also have a motion for supersedious bond.
You're absolutely correct. Once you file your notice of appeal, the supersedious bond statute will go into effect. You'll then have a hearing on your motion. But the first event that has to happen is the notice of appeal. Once that's happened, send it to my JA for your information. Ursula Nathy is my current JA. Next week, my new JA will be Julie Cochran. Her email address will be circulated on the website. It'll be J. Cochran. So file your notice of appeal. You can either reiterate the motion you've already done on supersedious bond or file a new one, and then I'll set a hearing time that's commensurate with both of y'all's calendars, Mr. Coleman and you're my JA, I'll work with you on that, okay? And if you're not gonna handle the appeal and you got a public defender, please get your paperwork in sooner rather than later.
We have an attorney.
Thank you. Court's adjourned.
All right, great.
And I'm adjudicating her guilty, okay? For the record.
All right, thank you. Ms. Rodriguez, the verdict of the jury reads as follows, dispensing with the caption, jury verdict, count 1, murder in the first degree. We, the jury, find the defendant, Stacy Marie Rodriguez, guilty of murder in the first degree, signed by the foreperson. Jury verdict, count 2, first degree arson. We, the jury, find the defendant, Stacy Marie Rodriguez, guilty of first degree arson, signed by the foreperson. Jury verdict, count 3, tampering with a deceased human body. We, the jury, find the defendant, Stacy Marie Rodriguez, guilty of tampering with a deceased body, signed by the foreperson. And then, I'm sorry, to go back to count 2, jury verdict, count 2, first degree arson, verdict question form. We further find with respect to the verdict question for this count as follows. Did the prosecution prove beyond a reasonable doubt that the arson was of an occupied structure? The jury has marked yes, and that is signed by the foreperson. Jury verdict, count 4, excuse me, second degree burglary arson. We, the jury, find the defendant, Stacy Marie Rodriguez, guilty of second degree burglary arson, and that verdict is signed by the foreperson. Jury verdict, count 4, burglary arson, verdict question form. We further find with respect to the verdict question for this count as follows. Did the prosecution prove beyond a reasonable doubt that the structure burglarized by the defendant was a dwelling? The jury has selected yes, and that is signed by the foreperson. And then finally, jury verdict, count 5, second degree burglary theft. We, the jury, find the defendant, Stacy Marie Rodriguez, guilty of second degree burglary theft. That verdict is signed by the foreperson. Jury verdict for count 5, burglary theft, verdict question form. We further find with respect to the verdict question for this count as follows. Did the prosecution prove beyond a reasonable doubt that the structure burglarized by the defendant was a dwelling? The jury has selected yes, and that verdict form is signed by the foreperson. Madam Foreperson, is this the verdict of the jury? All right.
All right, and Ms. Gillan, I'll allow you to remain there, but I just will ask you and your attorneys to please stand while I'm imposing sentence. Typically, I would have you come forward, but I want you to be able to rely on the walk or the table if you need to, ma'am. So, and I just want to take this opportunity to remind everyone as well that no outbursts or emotional expressions will be tolerated. You'll be removed from the courtroom if that does happen. So to kind of reiterate, Ms. Gillan, you're here on the counts that your attorney stated. You've got the 1 count of assisting self-murder or manslaughter, 2 counts of aggravated assault with a firearm, and those refer to Mr. Jackson, the security officer, and Mr. Aponte, both of whom testified here today. And then you have that 4th count of aggravated assault on a law enforcement officer with a firearm. And there were 6 officers who were named as victims in count 4 of the indictment. So the score on the criminal punishment score sheet is 115 months, which would be 9 years, and roughly 8 months. The state, as you know, has agreed to waive the minimum guidelines and agreed to cap your punishment at 10 years prison. And I first want to talk about some of the testimony that I've heard today. And Ms. Gillan, I accept your testimony today that you've given with respect to the fact that Jerry was suicidal. I know there's no records that document that, but I accept what you stated, that he told you and continued to express that he was suicidal. I think that makes sense, that a husband would confide in his wife of 53 years with respect to his serious emotional condition. I accept your testimony, ma'am, that his condition was worsening. Can you hear me okay? Yes. Okay. I accept your testimony that you and Jerry jointly decided to commit suicide, that you believe that was the only way out. And I accept your testimony that you do not remember staff informing you about comfort care or hospice. I think the doctor testified honestly with respect to what hospital procedure is, but I think it's highly likely that that either didn't happen or that you don't remember it. Also, I accept Dr. Danziger's testimony that you continue to not be a risk of danger to the community and that you were suffering from some sort of mental health episode on the date of the incident. I want to point out that, as everybody knows, this is not just a case about you and your terminally ill or very ill husband, because we've heard from the fact, from the testimony today, that there are many other victims in this case. And by entering your plea, you've admitted to having pointed a firearm at 2 hospital employees. You've admitted to having pointed a firearm at many Daytona Beach police officers as well. And we've heard today that there were 34 patients, 33 other patients on that floor who potentially had their treatment, their medical treatment disrupted, not to mention putting them in fear for their lives and perhaps their family as well. And then I don't even know how many hospital employees and their family members were impacted by the decision that you made. And it has come out today that you're educated, you have a master's degree. Some of these letters described you as smart and patient and kind and generous and thoughtful, but your actions on that date were none of those things. And your attorneys identified in the sentencing memo a few other similar cases where an elderly defendant had killed his or her spouse in some type of a mercy killing where that spouse was seriously ill. And the difference between those 3 cases that were identified and this one is the other victims. And that's what makes this case different to me. A lot of the letters that were sent in and even some of the testimony today talked about aid in dying laws and how Florida should have such a law. This is not the proper venue to make that argument. I am not a lawmaker. That is not my focus. That's an argument that needs to go to the Florida legislature and them only. Now, that's not to say that I'm unsympathetic to you, ma'am, because I can't fathom the difficulty of watching your husband's medical condition deteriorate to the point that he was in that constant kind of pain and wishing that he were dead. I can't understand that. I can't begin to understand how difficult it would have been for you to actually pull the trigger to assist your husband in ending his own life. I do believe that that is what you did, and so the punishment that I'm going to impose in this case is related to the other charges against you primarily. I've heard from the victims today, and I am highly persuaded by that testimony about the trauma that was inflicted on them. So, ma'am, I am going to adjudicate you guilty. You will be a convicted felon as a result of this incident. I'm going to sentence you to 366 days DOC, that's prison, and you will get credit for the 42 days that you've served. That'll be followed by 12 years of probation. The probationary terms are that you have to write letters of apology to the civilian victims and the 6 law enforcement victims that were identified in the indictment. And then this is an important part of the sentence as well. I want you to perform a minimal amount of community service hours per month for as long as you're physically able to do that. I want you to do 8 community service hours a month, so that's maybe 2 a week. And I don't care what you do, but I want you to realize, ma'am, that your life still continues to have value and you can contribute to society. You can even do work from home, like telephone or even via an internet connection. Again, I don't care what you do, but I want you to give back and I want you to enjoy the feeling of giving back to others as well. And then last but not least, there's going to be a mental health evaluation as a condition of probation, and you'll have to comply with whatever, if any, follow-up is recommended. It could just be take medication, but whatever the professional recommends is what you'll have to do. There are court costs of $770 plus $100 cost of prosecution and $100 cost of investigation to the police department, and you'll have to pay those off as a condition of your probation. So they're going to take you into custody today to begin serving that sentence, and again, you'll get credit for those 42 days that you've already served. Is there anything else that I need to address today?
Nothing from the state, Your Honor. Thank you so much, Your Honor. I appreciate it.
Okay, thank you, folks.
Thank you.
Defendant is guilty of the following: count 1, first-degree murder, a class 1 felony and dangerous crime against children, committed January 20th, 2020. Count 2, first-degree murder, class 1 felony and dangerous crime against children, committed January 20th, 2020. That is victim B. Count 1 is victim A. Count 3, first-degree murder, a class 1 felony and dangerous crime against children, committed January 20th, 2020. Victim C. All are dangerous but non-repetitive offenses under the criminal code. In preparing for sentence, received and considered all of the following: the pre-sentence report, which includes some reference to victim next of kin, the requests in restitution amounts, the recommendation from pre-sentence report, which is in line with the stipulations of the parties in the plea agreement, the written separate statement by victim Aunt in this matter, the defense sentencing memorandum and any attachments, the state's sentencing memorandum, the defendant's criminal history, which is non-existent prior to these offenses, as well as the stipulations of the parties in the plea. This is a stipulated specific sentence. Does the state have anything they wish to add for sentencing, or do next of kin wish to make a statement?
I don't believe anybody's going to make a statement today, Judge, so
Okay.
it's just going to be me. Before I make my statement, I do know.
Just pull a microphone.
Absolutely. Sure. There is a restitution request, Judge, for $30,000 from the MCAO Compensation Bureau, so I didn't know what the defense's position was on that.
Judge, we would request a hearing on that. We would like to see the receipts on that.
Okay, what I'll do is I'll retain jurisdiction, and then I won't set anything today. If you guys aren't able to work something out, I will set something at that point.
My only thing I would add, Judge, is we've provided all the documentation to the defense, and so I don't know if they haven't reviewed it. We did get some emails from Ms. Warner about it, so I thought they had reviewed that, but if they're not going to stipulate, then maybe we just set a hearing.
Okay, I mean, I'm happy to set a hearing today. It's going to be a little bit, because of my schedule currently, my Fridays are full, but so.
I understand.
That's fine, Judge, and Ms. Henry will waive her presence for the purpose of the hearing.
Okay, thank you.
Judge, I'm going to be brief because obviously we did file a sentencing memo and it is a stipulated sentence. I would note, Judge, for the court that it is probably hard to find somebody who had a role in this case who hasn't been affected by it. I would put obviously the family and friends in there. You read the letter from the victim's aunt talking about how this has affected her, how it's affected the children's father. Obviously, there's friends that have been affected by it. It has had an effect on the police officers and the fire and medical personnel who responded to that scene that day. A lot of the fire personnel thought, because there was a miscommunication, they thought it was a drowning call. They thought they were responding out to a scene to try to save children, and when they got there, found out that there were already 3 dead children inside of the house when they got there. I know the defense noted this in their sentencing memo. I think we noted in ours. Some of the personnel, the first responders, are still in therapy and have been affected by what happened, even though this was 5 years ago. I would add attorneys to that list as somebody who himself responded out to the scene that day. Why this has had effect on so many people involved in this case isn't really a surprise. It's because the 3 victims, Zane, Maria, and Catalaya, are 3 innocent children, all under the age of 4. The defendant is obviously going to prison for the rest of her life because she did the unthinkable in this case, Judge. She had a duty to protect her children from anyone or anything who would try to harm them. But unfortunately, in this case, she was that thing. These 3 children in this case were completely helpless to protect themselves from her, to stop her from what she did to them that day. And all 3 of these murders against Zane, Maria, and Catalaya were senseless and quite frankly cruel. The defense noted in their sentencing memo that she is going to have to think about this and the effect that it's had for the rest of her life, and I hope she does, because she took the futures of 3 children away from them that day when she did what she did. In terms of the mitigation, Judge, I'm not going to touch much on it because I think the defense will articulate it better than I will today. I would note that the defendant, Ms. Henry, took responsibility for this when she admitted to the police what she did that day when they interviewed her, and she's obviously taken responsibility now when she entered into this plea agreement for natural life in prison. In terms of the other mitigation that's in the defense's sentencing memo, and I'm sure they'll talk a little bit about today, that is all information that our office took into consideration, Judge, when we made what was a very difficult decision in this case to come to this plea agreement and to not go forward, obviously, with the death penalty. Based on everything, Judge, we do believe that this plea agreement is in the interest of justice. We are asking the court to accept the stipulations in the plea agreement and sentence the defendant to 3 consecutive sentences of natural life in prison. And that is based on, obviously, the aggravating and the mitigating factors, Judge. That's all I have. Thank you.
All right, thank you. Mr. Tavazzoli?
Thank you, Judge. May I remain seated?
Yes.
For my comments? Thank you. First of all, I would like to express my deepest sympathies, condolences for the loss of Zane, Maria, and Catalaya. They were so young and their lives were tragically taken from them. I'm personally deeply sorry for their loss, and Rachel is as well. This is a tragedy of monumental proportions, and we are here on this solemn day to give this tragedy a final resolution. Next, I would like to say that we believe the sentence in this case is appropriate. We can never bring back the lives of these 3 children, but Rachel is ready to begin to make up for that, for this unfathomable loss of her children by spending the rest of her life in natural life in prison. It is no small sacrifice, but it is one that she's willingly and sorrowfully accepting as she's entered into the plea agreement. This begs the question, why did this happen? Ms. Warner and I have had this case for 5 years. In that time, we have explored different theories in the case and have concluded there were a variety of factors that led to this tragedy. And had any of these factors not occurred, it may have prevented the deaths of these children. There was strong evidence of postpartum depression, mood disorder, dissociation, severe depression, fetal alcohol spectrum disorder, and that can explain some of Rachel's mental state at the time. Her social history, much of which was provided to the court and is incorporated into the sentencing memo, is also another clear factor. And the complete lack of support that she experienced at the time of the offense is another factor, Judge. However, even though we've investigated this case, it is still kind of a mystery in the sense that we may never know exactly what was going on that day with Rachel, and Rachel can't explain it or remember it herself in any articulable way that can make sense to herself and to everyone else. It's important to note that this is an explanation for these horrible offenses, and not an excuse. In no way does it justify what she's done. For those people that have only a fraction of the information about her case in the media, not knowing anything about who she is, and who have tried to capitalize on her case, I would like to say that she will be punished for the rest of her life. Not only will she be imprisoned and given no chance to get out, but she will live with the knowledge of the gravity of her offenses and must live without the loving presence of her children for the rest of her life. It's also important to note that up to the time of their deaths, Rachel was always described as a loving mother. In the time that we have represented her, she's always been kind and thoughtful, providing us all with origami figures she's made for us, me and my staff. Equally important is the fact that in the 5 years that she's been in the Estrella jail, which can be is described as kind of a junior high school on steroids, she hasn't received one ticket for misbehaving, and that's nothing short of a miracle in there, Judge. Especially with Rachel being diminutive, she's an easy target for bullies and other negative behavior that's directed toward her, particularly in light of the charges. Like I said, the sentencing memo that we provided to the court covers the vast majority of her mitigation, so I won't revisit those in these remarks. I do want to say that I do believe Rachel has accepted her responsibility and her fate, and she's ready to go to prison and try to be a positive influence in that world, even though it's going to be a restricted life that she's going to lead. And finally, I'd like to thank Chris and Jesse from the Maricopa County Attorney's Office and Catherine Ferguson Gilbert, who was on the case before, for helping us to resolve this case in a very appropriate way. I think they were very fair and professional in the course of our relations with them. I also want to acknowledge, as Mr. Sammons has said, that there were a lot of first responders that were affected by this case, severely traumatized. Finally, I'd like to acknowledge that because it affected the law enforcement, not only, I think Chris kind of mentioned this, but everybody was affected by this case. Law enforcement, the firefighters, even your court staff, this court, our defense team and the attorneys, the county attorney's office, everybody who's touched this case has been affected by it. We're forever changed by the deaths of these children, and life will never be the same for those, for the lives that their lives have touched. So with all that said, Judge, we ask that the court follow the recommendation in the plea agreement and sentence Rachel Henry to 3 consecutive natural life sentences. Thank you.
Okay, thank you. Ms. Henry, is there anything you wish to say?
No, Judge.
Oh, okay. Any legal cause?
No, Judge.
All right. Let me get hearing on the restitution first, and then I'll pronounce sentence. How long is the hearing itself going to take if it goes, do you think? An hour at most?
An hour at the most, Judge.
So April 25 is, well, hold on a second. I'm sorry, I could do April 4 at 11 o'clock. That works.
That works for us.
Let me double check my calendar.
Sure.
It's always on the slow. That's fine, Your Honor. Thank you.
Okay.
Yeah, that's good, Judge.
All right, and obviously if there's an agreement to something, we can vacate that. So it's ordered setting a restitution hearing April 4th at 11 o'clock. Ms. Henry's presence will be waived.
Thank you, Judge.
Okay. All right, the court has considered now the statements of all the parties. There's not much more this court can add. This is obviously one of the more horrific cases that this court has ever had before it. The court, however, greatly appreciates both memorandums from the parties, especially, frankly, I guess the defense memorandum that adds context to, doesn't explain anything, but adds context to perhaps what leads up to something like this. The court also agrees that the resolution in this matter is a just resolution, and that the state, in dropping the notice of death with the plea agreement in the decision making, came to a very just decision in doing so. As to counts 1, 2, and 3, then the court finds that probation is not appropriate. The court finds, based on the fact of the dropping of the notice of death, there's only one sentence that may be imposed on each count. It's therefore the judgment of the court as follows. As to count 1, imposition of sentence, defendant is sentenced to a term in the Department of Corrections for a term of natural life to begin today's date. I will give credit on count 1, which is 1,852 days of credit. As to count 2, it's ordered the defendant be imprisoned in the Arizona Department of Corrections for a term of natural life. That should be deferred, Monica. All right. With 0 days credit. As to count 3, defendant to be sentenced to the Arizona Department of Corrections for a term of natural life with 0 days credit. It is ordered that count 3 shall run consecutive to count 2, and count 2 shall run consecutive to count 1. The court notes first that the plea calls for consecutive sentences, and the court is following the plea agreement. Secondly, the court also finds that each victim deserves to be recognized as an individual victim, and consecutive counts are therefore warranted to consider the impact, obviously, on each victim from Ms. Henry's actions. Therefore, the consecutive sentences are warranted in this matter. The court will retain jurisdiction over restitution on count 1 for a period of 5 years, waives the defendant's appearance. Financials to be imposed on count 1 beginning today's date: a $20 time payment via $20 probation assessment, $13 criminal assessment, victim rights of $9 and $2. It is ordered dismissing counts and allegations in paragraph 3, with defendant to undergo DNA testing for law enforcement purposes. Ms. Henry, because you did plead guilty, You do have the right to petition the court for post-conviction relief and have a lawyer represent you. If you can't afford a lawyer, one will be appointed to you. If you can't afford copies of the necessary records and transcripts, they'll also be provided to you at no cost. If you want to petition for post-conviction relief, you'll file a notice within 90 days of today, or you lose the right to seek that relief. You understand that the conviction suspends your civil rights, including your right to vote, serve as a juror, hold public office, and firearm rights. Actually, let me back up. You're going to sign in a little bit for a copy of your post-conviction relief rights. You'll leave us a fingerprint. Have the ability to apply to set aside any convictions as provided by law. Again, the convictions suspend any civil rights, including right to vote, serve as a juror, hold public office, and firearm rights. You may apply at some point to have civil rights restored. The granting of that will be at the discretion of the court. It will not apply to restoration of firearm rights if convicted of a dangerous or a serious offense. You may also be able to petition the court for an order sealing all records of your arrest, conviction, and sentence related to the offense. If I didn't already say so, it is further ordered that a copy of the order of confinement, together with all pre-sentence reports, probation violation reports, medical and psychological reports not sealed, are remitted to the Arizona Department of Corrections. It's order remanding the defendant to the custody of the Arizona Department of Corrections to begin her sentence today, with all other orders not specifically stated reduced to writing. Is there anything else from the state?
No, Judge.
Any else from the defense?
Yes, Judge, there's one other thing. Miss Henry, because she didn't have a prior criminal history, she voted in the last election, and as a result, she's been called for jury duty in March. So we would ask that the court maybe, if you could vacate that for her.
I don't know procedurally how I could do that. Let me follow up with the jury commissioner to make sure, though, that she's taken off any list.
Thank you, Judge.
Okay. All right, anything else?
No, Judge, that's
okay.
it.
So I think we'll take Ms. Henry out, and then she will return sometime later to sign all her paperwork.
Thank you.
Okay, thank you. Is it all good to sign? Okay. Okay. Thank you. Probably turn off the FTR. Right.
All right, we're back on the record in State of Florida versus Ashley Benfield, 2020 CF 3014. I've been informed there's a verdict. Prior to bringing the jury out, I did want to make this announcement. The jury has reached a verdict, and I'm about to bring them out so the verdict can be reviewed and published. I know many of you here in the audience have been here throughout the trial, and I want to thank you for conducting yourselves appropriately throughout the trial. I realize that the reading of the verdict can be very stressful, and it is likely that some of you will agree with the jury's verdict and some of you will not. As sometimes happens, it may be that no one is pleased with the jury's verdict. Whatever your personal feelings are about this jury's verdict, I ask you to remember that these jurors were randomly selected from our community. They were thoroughly questioned by the court and lawyers for both sides, and they were selected from the larger group to hear this case because of their demonstrated ability to be fair and impartial. I've paid close attention to this jury, and they have been attentive, observant, and focused throughout the trial. No matter how much you agree or disagree with the verdict, there are to be no outbursts of emotion. Our judicial system, in fact our entire society, has relied on jurors to help resolve disputes for over 200 years. Their verdict needs to be respected even if you don't understand it or don't agree with it. You ready to bring in the jury?
Yes, sir.
All right, bring them in. All right, you all can have a seat. Members of the jury, I understand you have a verdict, and we have a foreperson.
Yes, we do.
Ma'am, has the jury reached a verdict?
Yes, we have.
Is the verdict unanimous?
Yes, it is.
Would you please hand the verdict form to the deputy? I need to check it and make sure it's in proper form. Thank you. All right, the verdict appears to be in proper form. Madam Clerk, would you please publish the verdict?
In the Circuit Court of the 12th Judicial Circuit in 4 Manatee County, Florida, the State of Florida versus Ashley Benfield, case number 2020 CF 3014. Verdict. We, the jury, finds as follows as to the defendant in this case. The defendant is guilty of manslaughter, a lesser included offense. Did Ashley Benfield actually carry a firearm? Yes. Did Ashley Benfield discharge a firearm? Yes. Did Ashley Benfield, as a result of discharging a firearm, cause death to Douglas Benfield? Yes. So say we all this 30th day of July, 2024, at Bradenton, Manatee County, Florida. Cheryl, foreperson.
Would either side like the jury polled? State?
No.
Defendants?
Yes, sir.
Members of the jury, you're now going to be polled. The clerk is going to ask each of you individually if this is your verdict and the verdict of the jury as a whole. Madam Clerk?
Juror number 15, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 20, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror 21, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 29, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 33, is this your verdict as well as the verdict of the jury as a whole?
Yes.
And juror number 35, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Thank you. Members of the jury, I want to thank you for your time and consideration in this case. I know that many of you have missed important work obligations and family obligations and other engagements that you had planned, as well as time with your families. But I want to thank you for being willing to give us your time and your attention and being observant to this entire trial and serving as jurors and doing your civic duty. I have paperwork that we're going to give you that will reflect your service as a juror, as well as a piece of paper from the clerk's office documenting that each of you has been here for these number of days if you need it for work purposes. If you need some sort of other paperwork for work or anything like that, contact my judicial assistant and we'll be able to get that for you. I also want to advise you of some very special privileges that all jurors enjoy. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak with anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. Bless you. It will be up to you to decide whether to preserve your privacy as a juror or not. Again, on behalf of myself, the entire judges of the 12th Circuit, thank you very much for your time and your attention during this trial. I now discharge you as jurors in this case and release you from any further obligations in this matter. You're free to go. Make sure you pick up your electronic devices, and please make sure that your notes stay with the deputy. They are going to be returned to me. They will be destroyed. No one will ever read your notes. Thank you. All right, you all can have a seat. The jury is out. State.
Judge, I would ask you to unnamed the defendant at this point. I believe she has a right to a PSI for sentencing, so I'm not sure if she would waive that or proceed with that.
Do you want to PSI?
I think we'd prefer to have the PSI.
I'll sign an order tonight for that. It's a late in the evening. My judicial assistant will reach out to both of you tomorrow to begin coordinating a hearing, sentencing hearing. You can let her know how much time you need. Right now, the pre-sentence investigations are running a month to 6 weeks, so it'll certainly, the time for sentencing will be outside of that, but then you can let me know how much time you'll need.
Let me direct myself, Your Honor, to post-trial release if I can.
Yes, sir.
Under Youngston, I know that the Younghans, rather, I know that the court is familiar with the standard. They stated in no uncertain terms, but if taken in good faith on grounds not frivolous but fairly debatable in view of the decisions of the Supreme Court, then the petitioner should be admitted to bail. And they set out for the trial court 3 factors. The first, with respect to the appeal not being frivolous, I think by the court's own acknowledgement at 2 different points in the trial, the court noted that we were dealing with novel issues that the court had not seen before. I think we certainly have good and sufficient grounds to appeal in good faith. The factors, according to Younghans, Your Honor, is the habits of the individual as respect for the law. Ms. Benfield has no prior history of criminal activity, as the court knows. Her local attachments to the community by way of family ties, business, or investments. She lives here in Bradenton, has lived here for a while. Her mother resides here. Her child resides here. The severity of the punishment imposed for the offense, that is substantial. There's no denying it. And any other circumstance relevant to the question of whether the person would be tempted to remove herself from the jurisdiction of the court. Ms. Benfield, on every single occasion over the course of the life of this case, has appeared when requested. She has never once failed to meet any obligation pursuant to the bond that she's on. As a result, we ask that the court entertain setting a post-trial bond. The only other thing that the court noted in the Younghands decision was that it's axiomatic that the exercise of judicial discretion should never be arbitrary, capricious, or unreasonable, and where the discretion is exercised in favor of denying to a person a basic and fundamental right, the reasons for doing so should be sound and they should be clearly stated. So pursuant to Rule 3.691, post-trial release, Your Honor, we ask that the court admit Ms. Benfield to bond, continue her on the same bond, in fact, and if the court is not inclined to do so, we ask that Your Honor stay the decision so that we can appeal directly to the second district. As the court knows, it's an accelerated docket because of the nature of the motion, that is to say, the bond.
Thank you. State, did you want to be heard?
Judge, I object to any bond at this point. The potential sentence is 30 years. While this defendant may have appeared at every court hearing, she was not convicted of the charge at the time. She has much more at stake at this point, being convicted of this crime, and I would ask you to deny bond.
Any rebuttal? Ms. Benfield, the jury, having found you guilty of manslaughter with a firearm, are going to remand you to the custody of the Manatee County Sheriff. We're going to revoke your bonds where you'll be held pending sentencing.
All right, I'm advised that the jury has arrived at a verdict. Again, as before, I will expect no outbursts either way upon reading the verdict. Are there matters that we need to discuss before we receive the verdict?
Not from the state, Your Honor. Thank you. No, Your Honor, not from the defense.
Bring in the jury, please. Madam Foreperson, has the jury arrived at a verdict?
Yes, Your Honor.
Would you please hand the verdict form to the bailiff, who will transmit it to me? Will the defendant please rise? In the case of State of West Virginia versus Natalie Paige Cochran, case number 23-F-343K, the verdict is as follows. Having found the defendant guilty of murder of the first degree, we, the jury, recommend the following. We, the jury, unanimously do not recommend mercy.
The verdict form is signed by Holly Rich, foreperson of the jury. It is dated 1/30/2025. Does the state wish to examine the verdict as to form?
No, thank you, Your Honor.
Does the defense?
No, Your Honor.
You may be seated. Is there a request that the court poll the jury?
Not for the state, Your Honor. No, Your Honor, thank you.
The court will receive the recommendation of the jury. It will be recorded and received fully by the court. The court has no discretion in this matter. I'm not sure that it would be useful to have a pre-sentence report or to even come back for sentencing.
Post-trial motions, Your Honor.
We certainly can deal with post-trial motions, but the court, I believe, will go forward with sentencing at this time. I'll ask the defendant to please rise. It is the judgment and ruling of the court that the defendant, Natalie Paige Cochran, be and she is committed to the penitentiary of this state for her natural life without the possibility of parole. I'll preserve all defense exceptions to the sentence imposed. You may be seated. Members of the jury, I appreciate your service. This is no comment at all on your verdicts, but you have been here. You have done everything that the court has asked you to do. You have been attentive. You have paid attention to all matters presented before you. I can excuse you from this trial, but I cannot release you from service. And so you are now pros in terms of jury service, and you will have to be available until May, the May term. It is very likely that you will be called in for other trials, civil or criminal. And so you know what to expect. You know what the situation involves. Thank you very much. We could not operate without you, and I sincerely appreciate your cooperation and patience. You may now follow the bailiff to your jury room and depart with the court's sincerest appreciation. All right, I'll ask the state to prepare an order in the premises. Is there anything further that we need to discuss?
This may seem like a silly point, but is the court sentence imposed consecutively with the federal sentence? Or?
I think it is a sort of unusual question, and I don't know that it makes any difference, to be honest. I'll run it concurrently with the federal sentence.
Yes, thank you. Yes, Your Honor.
Anything further? And of course, we'll schedule all motions, hearings. The court will certainly take up appropriate motions to be filed by the defense.
Of course, it's academic, Your Honor, but we will need to figure out, nevertheless, the credit for time served in this case, which may or may not have some type of impact in the future. Secondly, we need, well, this is more of a question of the court. The court envisions a hearing on post-trial motions, and at that time, I do believe that the court will have to reaffirm the sentence if the court rejects our motions, because the time of the for the appellate purposes will have to start running from a very specific date, and that is the date of the entry of the sentencing order. So I think that the court will have to re-sentence the defendant if the court rejects our post-trial motions.
The
So we
court
can
will
have.
certainly do that. I've done that many times in the past, and we can do that to accommodate the time for appeal. I can set a hearing date for post-trial motions. I'm looking first at February the 24th, 2025 at 9 a.m.
1st of February, Your Honor. Is that what you?
February the 24th.
Oh, 24th.
Your Honor, I need just a few minutes to pull up my calendar.
Okay, take your time.
Judge, I'm sorry, I already know I cannot do that.
Okay, February the 25th, 2025 at 9 a.m.
That's more like it, yes.
I believe that would correspond to my schedule, Your Honor.
Is that agreeable with the state?
It is, Your Honor.
All right, we'll set down February the 25th, 2025 at 9 a.m. To take up any post-trial motions. Is there anything further that we need to discuss?
I also believe that at that time, the court would advise my client of her right to an appeal and appoint counsel for the appeal.
Yes.
Very well.
Your Honor, I just have one query.
All right.
I do have an abuse and neglect case scheduled for the afternoon. Does the court have any anticipation of how long this will take?
I have the morning set aside. I can't imagine that it would run into the afternoon.
Thank you, Your Honor.
All right, we are adjourned.